This is the 2 p.m. calendar on May 11th, 2026. Orders are given on the first of the month regarding the taking of DNA and fingerprints. Those orders are made in effect today. What that means for you in the courtroom is this: not every single one of you has to give your DNA or your fingerprints. If you have to do that, those orders are going to be on your paperwork. My name is Commissioner Beck. I'm here to do a few things for you. Number one, I'm here to let you know why you're here. Number two, if you might be released. Number three, if you're going to be assigned an attorney. The vast majority of you will be assigned an attorney, which leads to my number one rule. Please don't talk about the facts of your case. Anything you say or do can be used against you. Everything in the courtroom is video recorded. So please don't talk about the facts of your case unless it's with your attorney. Second, I'm sure you're going to have a lot of questions for me. Unfortunately, I'm not your legal counsel, so I can't answer legal questions for you. So please save those types of questions for your attorney. Finally, you're going to be hearing about lots of different dates and different types of release conditions. You don't have to memorize all that stuff. All that information is going to be on your paperwork. That's why it's important to keep your paperwork and save it. Don't lose it. If you end up missing a court date or you don't follow a written court order, you could just end up back here. When it comes to those release conditions, when I see you in court, I'm only going to tell you about some of them, not every single one of them. For a complete list of all your release conditions, please refer to your paperwork. Here's how the afternoon is going to go. I'm going to call two names. The first name I call is going to come in the courtroom and stand in front of me at the podium. The second name I call is going to sit on that chair next to the door. Then we're going to keep on cycling through until the calendar's finished. I'm now going to read the victim's rights advisement. If you're the victim of a crime with a case pending before this court, you're advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present in court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on a release, negotiation of pleas, scheduling, and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. Okay, please get Demarion Acho to the podium, Thomas Salas to the chair. Name and date of birth, please.
04/09/2004.
Your name, please.
Demarion Acho.
Thank you. I apologize for mispronouncing your last name.
You okay?
You're here today on a Superior Court new case and a probation violation warrant. We would talk to you about your new case. You've been arrested for armed robbery, a Class 2 felony, possession of a weapon by a prohibited person, a Class 4 felony. I found probable cause, and I'm assigning you an attorney. Your next court dates are May 18th and May 20th in the Downtown Superior Court, setting a secured appearance bond of $100,000. You also have a probation violation warrant. I'm assigning counsel. Your next court date on this is May 18th in the Downtown Superior Court, finding probable cause as to a new Term 1 violation, setting a secured appearance bond of $1,000. So I have a total of $101,000 secured appearance bond. If you're able to bond out on both matters, you're going to be placed on supervised release with an electronic ankle monitor. Furthermore, if you bond out, you're not to return to the scene of the crime, no contact with any victim or witness, no contact with your co-defendant. You're not to possess any weapons, drugs, or alcohol. You must continue to obey the order of protection that's out against you. And if you bond out, you got to contact your PO within 3 days. Do you have any questions for me?
No, sir.
All right, thank you. Please go ahead and step to your left for your paperwork. Thomas Salas to the podium. Melanie Grayson to the chair. Name and date of birth, please.
Yes, Thomas A. Salas Jr., 7/22/1970.
Thank you.
Yes,
You're here today on a Superior Court new case. You've been arrested for disorderly conduct with a weapon, Class 6 felony, assault, Class 1 misdemeanor, disorderly conduct, Class 1 misdemeanor. I found probable cause, and I'm assigning you an attorney. Your next court dates are May 18th and May 20th in the Downtown Superior Court, setting a cash bond of $75,000. If you're able to bond out, you're going to be on supervised release with an electronic ankle monitor. Furthermore, if you're able to bond out, you're not to return to the scene of the crime. That means you can't go back home. No contact with any victim or witness. You cannot reside at the same location as any alleged victim. You're not to possess any weapons, drugs, or alcohol. You must find an alternative residence and provide proof of that residence. You must obey the terms of any orders of protection that are put out against you. And you may have no contact with any victims whatsoever, including electronically or through third parties, even if they contact you first. You're warned that a violation of a no victim contact order can lead to further felony charges. Do you have any questions for me, sir?
No, sir.
Thank you. Please go ahead and step to your left for your paperwork. Melanie Grayson to the podium, Joseph Figueroa to the chair. Name and date of birth, please.
Melanie Grayson, 10/20/1985.
10/20, it's not 5/10?
No, someone got it wrong somehow.
Okay. Ma'am, you're here today on a Superior Court new case. You've been arrested for aggravated assault with Class 3 felony. I found probable cause, and I'm assigning you an attorney. Your next court dates are May 18th and May 20th in the Downtown Superior Court, setting a secured appearance bond of $75,000. If you're able to bond out, you're going to be on supervised release with an electronic ankle monitor. Furthermore, if you bond out, you're not to return to the scene of the crime. No contact with any victim or witness. You cannot reside at the same location as any alleged victim. You're not to possess any weapons, drugs, or alcohol. You must find an alternative residence and provide proof of that residence. You must obey any terms of orders of protection that might be placed out against you. And you may have no contact with the victim whatsoever, including electronically or through third parties, even if they contact you first. You're warned that a violation of no victim contact order can lead to further felony charges. Do you have any questions for me then?
Yes. You said $75,000?
Correct.
So why am I having a bond that high when I was assaulted and then stabbed my spouse or my baby daddy that doesn't live there? Why am I getting that when I defended myself when I was in danger?
So the facts of the case,
Yeah.
and that's something you need to discuss with your defense attorney. What I have is a report, a summary from the police officer that states that you allegedly stabbed an individual. Given the serious nature of the charges here, and given the fact that this is a domestic violence related offense, that's why you have the $75,000 secured appearance bond. Ma'am, it's not a cash bond. You can use a bond company. So you're not, if you use a bond company, you're not responsible for paying the full $75,000.
So I just have to come up with $7,500.
Most people think it's just 10%. Depends on the company. It's between 10 and 15% plus fees.
Okay. And when's my next court date?
Your next court date is going to be May 18th.
Okay. So I'm stuck here.
Unless you can bond out, you're going to remain in custody.
Thank you so much for finding me guilty before I actually am.
Please go ahead and step to your left for your paperwork.
Wait, where do I go?
Over there.
Bullshit, man.
Joseph Figueroa to the podium, Tom Thompson to the chair. Name and date of birth, please.
Yes, sir. My name is Joseph Figueroa, 12/31/2007.
Thank you. You're here today on a Superior Court new case. You've been arrested for aggravated assault, Class 4 felony. I found probable cause, and I'm assigning you an attorney. Your next court dates are May 18th and May 20th in the Downtown Superior Court, setting a secured appearance bond of $5,000. If you're able to bond out, you're going to be on supervised release You're going to be alcohol tested and monitored. You're going to have an electronic ankle monitor.
Mm-hmm.
Furthermore, if you bond out, you're to have no contact with any victim or witness. You're not to possess any weapons, drugs, or alcohol. Do you have any questions for me?
No, sir.
All right, thank you. Please go ahead and grab your paperwork, step to your left. Tom Thompson to the podium, Cody Quinlan to the chair. Name and date of birth, please.
Thomas Carruthers, April 24th, 2007.
All right, that's not the name that we have here.
Yeah.
Have you gone by any other names?
Never. I've told them Thomas every single time they asked.
What's your date of birth?
April 24th, 2007.
Has he been fingerprinted?
Yeah.
Hold on, Your Honor. He's answering up for the other Tom.
Thank you.
If you want to call the next person in.
Cody Quinlan to the podium. Elizabeth Adeogun to the chair. Name and date of birth, please.
Cody Christopher Quinlan, 10/18/1989.
Thank you. You're here today on a probation violation warrant. I'm assigning you an attorney. Your next court date is May 18th in the downtown Superior Court. At the request of your probation officer, because of a new Term 1 violation, I'm finding probable cause as to a new Term 1 violation, setting a secured appearance bond of $500. If you're able to bond out, you're not to possess any weapons, drugs, or alcohol. Most important thing, if you bond out, you got to contact your PO within 3 days. Do you have any questions for me, sir?
So it was a probation violation?
Yeah, apparently you were arrested for allegedly committing disorderly conduct, class 1 misdemeanor.
Yeah.
So that's
So you violated me for that?
so that's your new Term 1 violation.
Okay.
All right, thank you, sir. Elizabeth Adeogun to the podium. Cochran Donahue to the chair. I'm
The
sorry?
other gentleman's in here when you're ready.
All right, thank you.
Good morning,
Name and date of birth, please.
or good afternoon. Elizabeth Ajose Adeogun, April 1st, 1996.
Thank you. You're here today on a probation violation warrant. I'm assigning you an attorney. Your next court date's May 18th in the downtown Superior Court. I'm affirming the bond set by your probation violation judge. It's a $500 secured appearance bond. If you're able to bond out, you're not to possess any weapons, drugs, or alcohol. Most important thing, if you bond out, you have to contact your PO within 3 days.
I have a quick question. I
Sure.
just spoke with my parole officer last week, and he told me that he was going to do a re-engagement, so I'm not sure why I even have a warrant. Like, I literally just spoke with him, and he told me that the only reason why I couldn't meet with him that day was because I couldn't have my kids with me. So he knows, he has my new address, he knows everything, so I'm not sure why this even happened.
So he filed a petition to revoke your probation. He filed this is filed back on January 23rd.
Right, and I just talked to him, so I'm trying to figure out why it's still even in there.
Yeah, so this warrant's been out since January. You can keep on talking to him while that warrant is still out, and they pick you up whenever they pick you up. So that's why. Do you want to know the reasons why he asked to revoke you?
Probably because he couldn't reach me. I had a different number or something.
Yeah, so it's terms 3, 5, and 6. Term 3, he is alleging that you didn't report as directed on 1, 2, 3, 4, 5, 6, 7 separate dates. And he's also alleging that you didn't reside at a residence approved by the Adult Probation Department. He's also alleging that you did not submit to drug testing as directed by the Adult Probation Department on 2 dates last year. So
That's odd, because he came to my address, so that's so weird.
I understand, but those are the reasons why.
All right, and is it like you said a $500?
$500 security appearance
So
bond.
can I use a bondsman?
You can use a bondsman, so I'm gonna warn you though that, 10 to 15%, it's, it's gonna be around $50 to $55.
Yeah, I understand that.
But it's plus fees, and so if you add the fees, sometimes those fees end up being more than the 500, but that depends on the bond company. So some bond companies won't let you use them for a bond less than a certain amount. I'm just warning you. They may not be able to help you out. All right, any other questions? All right, thank you. Please go ahead and step to your left for your paperwork. Cochran Donahue to the podium, Tom Thompson to the chair. Name and date of birth, please.
Cochran, 14 Donahue, 31289.
Thank you. You're here today on a Justice Court warrant. I'm assigning you an attorney. Your next court date's going to be May 13th at the West McDowell Justice Court.
Your Honor, I already have an attorney.
Okay, that's fine. You don't have to use the one that I assigned to you. So if you show up to court with your other attorney, that's totally fine. I'm affirming the bond set by the judge out there. It's a $400 secured appearance bond. If you're able to bond out, you're just not to possess any weapons, drugs, or alcohol. Actually, if you already have an attorney, let's see here.
It was appointed already. States Julio LaBoy.
It was already appointed to you before, so then you'll end up having him again, so that's fine.
He's appointed in this case currently.
I understand.
Okay.
So you're going to go back to him. All right, so again, if you're able to bond out, you're not to possess any weapons, drugs, or alcohol. I didn't change anything. Do you have any questions for me?
Yes, Your Honor. I'd like to do a motion for reconsideration.
So,
I just, please let me explain the situation.
Okay.
We just did a Rule 11 hearing in Superior Court where this case and another case was gone there. Then Julio LaBoy was gone out. I reside in New Mexico, as both judges are aware of, and I through great expense, I come out here, and with gas prices the way it is, I came out on May 7th. I was here, and I have a timestamp of me being at Sandra Day O'Connor Federal Courthouse at 9 a.m. to, take care of stuff. My attorney, if you let me give you my cell phone, I can show you, said he's going to do a motion for continuance. He expects to win, and it'll be fine. So I took that as I didn't need to show up. I then left at around 12 o'clock. He told me that he lost the motion. There was a warrant for my arrest. I came back to the courthouse, West McDowell, and they would not see me. So I left. Then I went today, this morning, to for another court case and had my status conference. But I was at the courthouse today to have the warrant quashed as well. So I'm not evading. I turned myself in effectively, and I would just appreciate it if you would consider releasing me on my own recognizance. I'm not evading this, and this is just a simple misunderstanding and a mistake. And I've tried to resolve it twice already. So if I could be released on my own recognizance, this is not going to happen again. It was just a mess up from the Rule 11 hearing, coming back, coming forth, things like that. It is a very small warrant as well, but if you could, gas prices and coming back, and it's a lot, even $400 right now. I have a 4-year-old daughter, and I'm just trying to do what I can.
what'd you go see Judge Marwell for?
There was a status conference. So again, the case in West McDowell was supposed to be just a status conference after the Rule 11 was cleared, and I was found competent.
Is this for your family court case?
Say it one more time, sir.
Judge Marwell, is this for your family court case?
Judge Marwell is not a family court case, no. I have custody cases, but that's a separate issue.
Right, if your Rule 11 was over, why did you need to see Judge Marwell?
For the status conference today to set new dates and set this, for Julio LaBoy got appointed at the Rule 11, and he asked for more time, so 60 days out, he said, and that was for the Superior Court case.
I get it. So what's this, but you're not here on a Superior Court case. This is for a Justice Court warrant.
Correct. That's two cases, and that's why that's why there was confusion. So I was at the South McDowell Justice Court.
Yeah, so, sir, I'm asking you what you have going on in the Superior Court.
It's an alleged theft case. I didn't steal anything. I know you probably can't take that at face value, but I'll win that case as well. It's just a misunderstanding, and they're refusing to pull inventory records. I worked there, and they're claiming that I stole it. I didn't steal anything. So I showed up for that case today.
Okay, so you didn't actually self-surrender, you just showed up to court because you're ordered to show up to court.
I showed up at West McDowell before the court date, and then I was there. So Julio LaBoy is my lawyer in both. He did a motion to quash this week, and it's supposed to be heard later.
Hasn't happened yet. Sir,
Yeah.
Go ahead and have a seat. Let me think about what I'm going to do with you, all right?
Thank you, sir.
Tom Townsend to the podium, Carino and Taveras to the chair. Name and date of birth, please.
Tom T. Thompson, August 17th of 87.
Thank you. You're here today on an out-of-county warrant. I'm assigning you an attorney. Your next court date's going to be May 14th at the Holbrook Justice Court. I'm affirming the bond set with the judge up there. It's an $800 secured appearance bond. If you're able to bond out, you're just not to possess any weapons, drugs, or alcohol. Do you have any questions, sir?
Yes, sir. So I'll be in custody until May.
Until May 14. Unless you can bond out, you'll be in custody until May 14.
Okay.
Any other questions, sir?
No.
All right, thank you. Please go ahead and grab your paperwork.
Holbrook, huh?
Carino Taveras to the podium, Devontae Miller to the chair. Name and date of birth, please.
11/13/1992.
Your name, please.
Carino Taveros.
Thank you. You're here today on a Justice Court warrant. I'm assigning you an attorney. Your next court date's May 14th at the North Mesa Justice Court. I am going to reduce your bond down to $100. If you're able to bond out, you're just not to possess any weapons, drugs, or alcohol. Do you have any questions for me?
Yes, I also have a case through Tempe.
We don't handle Tempe Court. I'm sorry.
Okay.
Yeah, we just handle a few of the courts, but we don't handle Tempe. We don't handle Phoenix. There's some other courts we don't handle.
Okay. They threw all my numbers away. I don't have any way to contact anybody. This is from a case from 14 years ago. Is there any way to forego the bond?
So at this point, I was going through your record. I know it's an older case, but it's been going on. And here's the other thing too. You've been back here ever since this case has been going on. Who saw you and released you? Commissioner McLaughlin saw you, released you, and you didn't take care of what you needed to take care of. Then you saw Judge Ash, then you saw Judge Jones, then you saw my colleague, Commissioner Campbell. She let you go, and you still didn't finish taking care of this. And so that's the issue that I have here.
Your Honor, the last time I did miss the court date because I thought on the paperwork it said the 29th, but it was the 23rd. And I was supposed to be going to open court this week for that to finish that, and had written a letter to the judge, and we had worked out a plan to do community service for the payment instead.
Ma'am, this is not for a failure to appear.
What?
This warrant is, from what I'm showing, is not for a failure to appear. It's a rules violation.
It's a what?
It's a rules violation for your prior DUI. So I don't know what you haven't followed for the Justice Court, but this isn't for a failure to appear.
The rules, I don't understand.
Yeah, I don't know, because I'm not the justice of the peace that put this warrant out for you. I'm not the one that put you on probation. All I'm here to let you know is what the warrant is for, and what court it came out of, and what your next court date is. So after considering everything, you've been let out on this a few times before, and you still haven't finished everything you need to finish. So, I mean, hopefully this is kind of a wake-up call for you to finish up what you need to. I reduced your bond down to $100, down from 500. So I'm going to keep that in place for now. So your next court date's going to be May 14th, North Mesa Justice Court.
Okay.
All right, thank you. If you want to please step to your left for your paperwork. Devontae Miller to the podium. Cody Hartle to the chair.
Good afternoon, Your Honor.
Name and date of birth, please.
Devontae Miller, 05-15-94, sir.
Thank you. You're here today on a Superior Court new case. You've been arrested for disorderly conduct with a weapon and Class 6 felony. I found probable cause. I'm assigning you an attorney. Your next court dates are May 26th and May 29th in the downtown Superior Court. Upon your promise to appear, I'm going to release you today. There's going to be a lot of conditions to your release.
Yes, sir.
You're going to be on supervised release. You're going to be alcohol tested and monitored on a weekly basis. You're going to have an electronic ankle monitor. You're not to return to the scene of the crime. No contact with any victim or witness. You're not to possess any weapons, drugs, or alcohol. Do you understand all these conditions?
Yes, sir. May I do...
One second. Do you promise to follow all these conditions?
Yes, sir.
You promise to appear on May 26th and May 29th in the downtown Superior Court?
Yes, sir.
Do you understand?
Yes, Your Honor, I'm sorry.
Do you understand if you don't show up, they'll issue a warrant for your arrest?
Yes, Your Honor.
Do you have any other weapons you need to give up?
Sir, I have no weapons at all. If I could do a motion to reconsider, sir.
Sir, I'm releasing you today. What's there to reconsider?
Just the fact that, so I oversee an addiction recovery facility. I'm clean and sober. I teach decision-making and impulse control. I don't own any weapons. I even gave the officer permission to search my vehicle because they said I looked like someone who had a weapon. They searched my vehicle and they found no weapons, and I gave them permission to search my vehicle. So for me going to work with the anger monitor where I work with addiction recovery specialists and mental health, having an anger monitor for someone who does not own or carry a weapon or make poor judgment calls, sir, I could accept that disorderly conduct, but for a weapon, sir, I've never owned a weapon in my life, and they were not able to produce any type of weapon.
And that's part of the reason you're being released today, sir. But all the other conditions, given the nature of the charges, I'm keeping all the rest.
The ankle monitor too?
The conditions, including the ankle monitor, sir.
Okay.
Upon your promise to appear, I'm going to release you to the supervision of pretrial services. It's your responsibility to call pretrial services once you're out of custody.
Okay.
You have to call them today or tomorrow during normal business hours. If you fail to call pretrial services, you could end up back here. Do you understand that, sir?
Understood, Your Honor.
Do you have any other questions for me?
No, Your Honor.
All right, thank you. Please go ahead and step to your left.
Thank you. Thank you very much.
Cody Hartle to the podium. Anthony Gonzalez to the chair. Name and date of birth, please.
Good evening. Sorry, what did you say?
Name and date of birth, please.
Oh, Cody Hartsell, August 4th, 97.
Thank you. You're here today on a municipal court new case. You've been arrested for disorderly conduct, a Class 1 misdemeanor, and criminal trespass, Class 1 misdemeanor. I found probable cause. I'm not assigning you an attorney because for these types of charges, you don't get a free attorney, but you can hire your own attorney if you want one. Do you understand that?
Yeah, I'm actually confused. Like, I was drunk last night, so I don't even know.
All right, so yeah,
what
one
my
sec.
charge
Let me finish up first, and then you can ask some questions, okay? All right, your next court date's June 1st. That's at the Peoria City Court. Upon your promise to appear, I'm going to release you today. There's going to be a lot of conditions to your release, though.
Okay.
You can't go back to the scene of the crime. No contact with any victims or witnesses. You're not to possess any weapons, drugs, or alcohol.
Okay.
Do you understand all these conditions?
Yes, I understand.
Do you promise to follow all these conditions?
Yes, I promise. I don't even remember where the scene was.
I'll let you know in
Okay.
one sec. Do you promise to appear on June 1st at the Peoria City Court?
June 1st. Yes, I promise.
Do you understand if you don't show up, they'll issue a warrant for your arrest?
Oh, no, I'm going to show up. Yeah.
Do you have any weapons you need to give up?
No, nothing.
All right. Upon your promise to appear, I'm going to release you on your own recognizance. So, let's see. You can't go back to 9816 West Karen Drive.
Okay, I don't even know whose house I is.
That's part of the issue. So you can't
Yeah.
go back there, and you also, ma'am, you understand that no alcohol while your case is going on. Do you understand that too?
Yes, actually, I've been good without alcohol until last night. Now I'm here. So.
All righty. Just make sure to follow all these rules, okay? Make sure to show up to court, okay?
Yeah. Can I ask you what they had a fight or something?
What?
I really don't remember. I sobered up and I
Yeah,
don't even know how many.
yeah, these are questions, you're,
Attorney?
yeah, well, you're not gonna get an attorney.
Oh, I
So
thought-
basically, criminal trespass was that address I told you about. You can't go back to that place. Disorderly conduct, you were allegedly banging on, trying to break down the door.
I was banging on the door?
You were trying to break down the door, okay?
I don't know, I don't even know
So
how that is, but thank you
So
for telling
anyway,
me.
so you can't go back there, all right, ma'am?
Yeah, no, thanks for telling me, because I was confused. I was like, I don't know.
All righty. Please go ahead and accept your left for your paperwork.
So I can leave now? Okay, thank you.
You're gonna be out, there's your papers. You're gonna be out in about 4 to 5 hours, okay?
Okay, thank you, I appreciate you.
Yeah, it'll take about 4 to 5 hours.
Okay, thank you.
Anthony Gonzalez to the podium, Cochran Donahue to the chair.
Good morning, Your Honor.
Name and date of birth, please.
Anthony Gonzalez, May 30, 2006.
Thank you. You're here today on a Superior Court new case. You've been arrested for unlawful flight from law enforcement, a classified felony.
Yes,
I
sir.
found probable cause, and I'm assigning you an attorney. Your next court dates are May 26 and May 29 in the downtown Superior Court. Upon your promise to appear, I'm going to release you today. There's going to be a lot of conditions to your release.
Yes, sir.
You're going to be on supervised release. You're going to have an electronic ankle monitor. You're going to have a curfew. You're not
I'm gonna
gonna-
be, oh, my bad, Judge.
Let me finish up.
Okay, my bad, bro.
You're going to have an electronic ankle monitor. You're going to have a curfew. You're not to possess any weapons, drugs, or alcohol. You can't drive a motor vehicle with anyone under the age of 18 in that vehicle.
Yes, sir.
Do you understand all these conditions?
Yes, sir.
You promise to follow all these conditions?
Yes, sir.
Promise to appear on May 26 and May 29 in the downtown Superior Court?
Yes, sir.
Do you understand if you don't show up, they'll issue a warrant for you?
Yes, sir.
All right. Upon your promise to appear, I'm going to release you to the supervision of pretrial services. You got to call pretrial services once you're out. You got to call them today or tomorrow during normal business hours.
Okay.
If you don't call pretrial services, you could end up back here. Do you understand that?
Yes, sir.
You had a question for me?
Would it, so like, do I call pretrial services to get the ankle monitor put on, or
No,
before I
they're
get
gonna give you an ankle monitor before you even get out of here.
Okay.
They're gonna put it on you before you get out.
All right, thank you, Your Honor.
Thank you. Go ahead and grab your paperwork first.
Have a seat on the left.
Cochran Donahue to the podium. Recalling Mr. Donahue's matter. All right, sir, you got multiple stuff going on, and honestly, with your other felony case going on too, I have every right to hold you just to put that bond on, whether you're able to pay that bond or not. But I'm gonna give you one last shot at this. So at this time, I'm making no order regarding counsel because you're not entitled to a free attorney, but it sounds like you already have Mr. LeBoy helping you out. Your next court date's gonna be actually now be May 26th at the West McDowell Justice Court. Upon your promise to appear, I'm gonna release you. There's some additions to your release. You're not to possess any weapons, drugs, or alcohol. You understand all these conditions?
Absolutely, sir.
You
Thank you.
promise to follow all these conditions?
Absolutely, yes.
Promise to appear on May 26th at the West McDowell Justice Court?
Yes, sir.
Do you understand if you don't show up, they'll issue another warrant for your arrest?
Yes.
Do you have any weapons you need to give up?
No, sir.
Upon your promise to appear, I'm going to release you on your own recognizance. Do you have any final questions for me?
Thank you very much, Your Honor.
All right, thank you. Go ahead and grab your paperwork and step to your left.
Have a great day, Judge.
Could we please clear the courtroom for our last person?
Did they change something? They didn't change it.
While we're waiting for the last matter, I have to visit one individual back in their cell. They pose a risk of harm to themselves or to others. John Chavez, date of birth 9/1/2004, here on a probation violation warrant. I'm assigning counsel. Next court date's May 18th in the downtown Superior Court. Affirming the bond set by his probation violation judge, $100 secured appearance bond. If he's able to bond out not to possess any weapons, drugs, or alcohol, must contact his PO within 3 days. After visiting with him back at his cell, if I have to make any changes to these release conditions, I'll come back on the record to make those changes. All right, Ms. Rodriguez? Name and date of birth, please.
Mariana Rodriguez, 3/10/2000.
Thank you. You're here today on a Superior Court new case. You've been arrested for child abuse, a Class 2 felony, endangerment, a Class 6 felony, endangering the life or health of a minor, Class 1 misdemeanor. I found probable cause, and I'm assigning you an attorney. Your next court dates are May 18th and May 20th in the Downtown Superior Court. At this time, I'm setting a secured appearance bond of $10,000. If you're able to bond out, you're going to be on supervised release with an electronic ankle monitor. Furthermore, if you bond out, you're to have no contact with any victims or witnesses. That means your children. You're to have no contact with any minors. You cannot live at the same location as any alleged victim. You're not to possess any weapons, drugs, or alcohol. You can't drive a motor vehicle with anyone under the age of 18 in that vehicle. You must obey any orders of protection that might be put out against you, and you may have no contact with the victims whatsoever, including electronically or through third parties, even if they contact you first. You're warned that a violation of a no victim contact order can lead to more felony charges. Do you have any questions for me, ma'am?
So I'm basically staying here, basically.
Unless you're able to bond out, you're going to be in custody.
Okay.
Any other questions?
No.
All right, thank you. Go ahead and grab your paperwork and step to your left. And this will conclude the 2 p.m. calendar.
Thank you. Please be seated.
The attorney for the health call is no longer health call has not populated yet. Same with health call.
Oh, okay. Hasn't populated. Okay.
No.
I see what you mean. Thank you. This is the 5:00 p.m. initial appearance calendar for May the 11th of 2026. The court's orders for the taking of DNA and fingerprints that were given at the first calendar date of this month shall apply to all matters on this calendar. I will now read the victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. With that, we will begin. Well, first, ladies and gentlemen, we're here today for an initial appearance calendar. What that means is that you're going to hear a little bit more about the allegations against you, whether or not you've been appointed counsel, your next court dates, and your release conditions. As I'll call you up, please approach the podium that is at the center of the courtroom right over here. If you are next, please sit in the chair that is at the front of the gallery. Okay, with that, we'll get started. Number 25 on the calendar, please. Ryan Auditor to the podium, please. Number 23 on the calendar, Dion Milling to the chair, please. And good evening, sir. Please tell me your name and date of birth.
Ryan Auditor, 11/27/88.
Thank you very much, sir. We are here today on a new case out of the Maricopa County Superior Court. Sir, there are 5 charges. The first is possession of dangerous drugs, Class 4 felony. There are 3 charges of possession of narcotic drugs, Class 4 felony. 1 charge of possession of drug paraphernalia, a Class 6 felony. For the 3 counts of possession of narcotic drugs, I was not provided sufficient information to determine probable cause for the 3 distinct charges of narcotic drugs, Class 4 felony. Here's what that means. Here's what that doesn't mean. What it means is that for tonight's purposes, that did not factor into my determination of release conditions. It does not mean that the prosecution still couldn't go forward in the event that the state thought it had enough evidence to get a conviction. So the moral of the story is you still do have to go to court. For the record, sir, I did find probable cause as to the dangerous drug and drug paraphernalia counts. All right? I'm going to appoint the public defender's office for you and set 3 court hearings. The first is a status conference and evidentiary hearing. That's one day, May 18th of 2026. Status conference at 8:30, the evidentiary hearing at 1:30 p.m. I'm also going to set a preliminary hearing on May the 20th of 2026. That's 8:30 in the morning. All of those are at the downtown Superior Court complex. Sir, given the nature of the allegations that a new felony offense was committed while out on felony release, Arizona law prohibits me from admitting you to bail. Therefore, I'm ordering that you be held without bail pending your evidentiary hearing on the 18th, sir. Do you have any questions?
No.
Thank you, sir. Number 23 on the calendar, Dion Milling to the podium, please. Number 26 on the calendar, Tyrone Kowalkowski to the chair, please. And good evening, Mr. Milling. Please tell me your name and date of birth.
Good evening, Your Honor. 7/11/1982.
And your name, sir.
Diony Milling.
Thank you, sir. We are here today on a grand jury warrant out of the Maricopa County Superior Court.
What is
Just a moment,
that?
sir.
What is a grand jury warrant?
Well, that means that a grand jury has determined probable cause and handed down an indictment accusing you of 3 felony counts. First, theft, a Class 2 felony. Second, trafficking and stolen property in the first degree, a Class 2 felony. Third, forgery, a Class 4 felony. All alleged on or about August the 20th of 2025. I am appointing the Public Defender's Office to represent you and setting 2 court dates. The first is an evidentiary hearing on May the 18th of 2026. That's at 1:30 p.m. The second is an arraignment on May the 19th of 2026 at 8:30 a.m. Sir, because there is an allegation that a new felony offense was committed while out on felony release for another felony offense, Arizona law prohibits me from admitting you to bail. Therefore, I'm ordering that you be held without bail pursuant to Arizona law, pending your evidentiary hearing on the 18th. Do you have any questions, sir?
Will my evidential hearing be guaranteed?
It's set currently for the 18th, sir.
Would it be guaranteed that I have one, though? Because I know they do the...
I've set it up on the calendar for the 18th, sir.
With you?
No, sir. That's going to be at the downtown Superior Court complex.
And it won't get scratched, right?
Unless there's some sort of subsequent scheduling order, but based on what I'm scheduling right now, it's on the 18th, sir.
Only reason I'm asking, Your Honor, because I know they scratch out preliminary hearings for grand jury indictments, but due to the fact the grand jury indictment already took place, I will be subject to a evidential hearing, right?
Well, sounds like you're getting into territory where you're asking a question that is really better suited for discussion with counsel as to whether a scheduling order may be modified moving forward and whether that's appropriate. So I'm going to defer to a conversation between yourself and counsel, sir, as to the modification of scheduling orders, how that occurs, okay?
Could I have the same counsel on the case?
I've appointed the Public Defender's Office in the event that, so this is the general appointment of the Public Defender's Office, and that'll be assigned internally.
Okay.
All right. Any other questions, sir?
No, sir.
All right, thank you very much. Please step to your left. Number 26 on the calendar, Tyrone Kowalkowski to the podium, please. Number 29 on the calendar, Danielle Hawkins to the chair, please. And good evening, Mr. Kowalkowski. Please tell me your name and date of birth.
Tyrone James Kowalkowski, 8/29/1987.
Thank you very much, sir. We're here today on an arrest warrant out of the Maricopa County Superior Court. This is a direct complaint alleging one charge of shoplifting with 2 or more predicate priors, a Class 4 felony, alleged on or about March the 5th of 2026. I am appointing the Public Defender's Office to represent you in setting 2 court dates. On May the 18th of 2026, you're going to have 2 hearings, one at 8:30 in the morning for a status conference and one at 1:30 p.m. for an evidentiary hearing. On May the 20th of 2026, you'll have a preliminary hearing at 8:30 a.m. All these are going to be at the downtown Superior Court complex. Sir, because there is an allegation that a new felony offense was committed while out on felony release for a prior felony offense, Arizona law prohibits me from admitting you to bail at this time. Therefore, I'm ordering that you be held without bail pursuant to Arizona law, pending your evidentiary hearing on the 18th, sir. Do you have any questions for me? Thank you, sir. Number 29 on the calendar, Danielle Hawkins to the podium, please. Number 13 on the calendar, Roberto Osorio, to the chair, please. And good evening, Ms. Hawkins. Please tell me your name and date of birth.
Nice to meet you. My name is Danielle Hawkins, 11589.
Thank you very much. We're here today, Ms. Hawkins, on a new case out of the Maricopa County Superior Court. There's one charge of taking contraband into a correctional facility, a Class 2 felony, one count of possession of dangerous drugs, a Class 4 felony, one count of possession of drug paraphernalia. This is a reprint, a Class 6 felony. Get that fixed. Three counts of possession of narcotic drugs, a Class 4 felony, one count of taking contraband into a correctional facility, a Class 5 felony, one count of possession of drug, well, that's already found, the drug paraphernalia count. So as to the three counts of possession of narcotic drugs, I was not provided sufficient information to determine probable cause for those discrete alleged offenses. So here's what that means, here's what that doesn't mean. It means that for today's purposes, it did not factor into my determination of release conditions for your case. What it does not mean is that the prosecution still couldn't go forward in the event that the state thought it had enough evidence to get a conviction against you, okay? So the moral of the story is you still have to go to court. For the record, I did find probable cause as to the remaining counts. And I'm going to appoint the public defender's office to represent you and set 3 hearings. The first 2 are on May the 18th of 2026. One is a status conference at 8:30 in the morning at the downtown Superior Court complex. The other is an evidentiary hearing at 1:30 p.m., also downtown Superior Court. Likewise, the preliminary hearing is set for May the 20th of 2026 at 8:30 downtown Superior Court. Ma'am, because there's an allegation that a new felony offense was committed while out on felony release, Arizona law prohibits me from admitting you to bail at this time. Therefore, pursuant to Arizona law, I'm ordering that you be held without bail pursuant to, as I said, pursuant to Arizona law, pending your evidentiary hearing on the 18th at 1:30 p.m. Do you have any questions for me?
Yeah, so pretty much I'm just gonna have to wait till then and to figure out if they're gonna go forward with the charges and if I'm gonna be able to be released or if there's gonna be repercussions.
The subject of the evidentiary hearing is whether there's enough evidence to continue to hold you without bail. So please talk to counsel about how you'd like to approach that hearing, ma'am.
Okay.
All right, thank you very much.
No, thank you.
Number 13 on the calendar, Roberto Osorio, to the podium, please. Numbers 17, 18, and 19 on the calendar, Benjamin Baker, to the chair, please. And good evening, Mr. Osorio.
Good evening.
Please tell me your name and date of birth.
Roberto Osorio, 10/28/90.
Thank you. Sir, we're here today on a bench warrant out of the Maricopa County Superior Court. The date of the bench warrant is from April the 15th of 2026 from a failure to appear.
Yeah, I was
There's one
incarcerated.
underlying count of possession. I'm sorry, sir?
I was detained. That's why I didn't show.
Okay, and I'll get to that, sir. Thank you very much. And so there's one underlying count of possession of narcotic drugs for sale, a Class 2 felony. I'm going to affirm the appointment of existing counsel and set 2 court dates for you, sir, on May the 18th and 20th of 2026. Both of those are at 8:30 in the morning at the downtown Superior Court complex. I'll note that you're in sheriff's custody pursuant to a writ of habeas corpus from U.S. Immigration and Customs Enforcement. Therefore, you remain primarily in federal custody. Therefore, you must be held in custody pursuant to the terms of the writ of habeas corpus until case disposition so that you may be returned to federal custody. Therefore, pursuant to the terms of the writ, I'm ordering that you be held without bail until such time as the case is disposed. Do you have any questions, sir?
No.
All right, thank you, sir. Please step to your left. Numbers 17, 18, 19 on the calendar. Benjamin Baker to the podium, please. Number 11 and 12 on the calendar. Ryan Short to the chair, please. And good evening, Mr. Baker. Please tell me your name and date of birth.
Benjamin Lee Baker, 12/21/88.
Thank you, sir. We're here today on 3 cases. All 3 of these are probation violation warrants from the Maricopa County Superior Court. The adult probation department alleges that you have violated terms 3, 4, 5, and 7 of probation in 3 petitions to revoke your probation. Sir, I'm going to appoint the public defender's office to represent you in all 3 of these cases and set a combined probation revocation arraignment hearing and disposition hearing on May the 18th of 2026 at 8:30 a.m. at the downtown Superior Court complex. As to your first 2 probation violation warrant matters, I'm setting your bail at $500 pursuant to the probation violation court warrant. So that's $500 apiece on your first 2 cases. However, pursuant to the terms of the probation violation warrant on your 3rd case, sir, and additionally pursuant to Arizona Rule of Criminal Procedure 7.2C, I'm ordering that you be held without bail on your 3rd probation violation matter. And this will be a reprint. Do you have any questions, sir?
Yeah, what's the 3rd one?
The 3rd matter is a petition to revoke probation for burglary and theft. The date of the petition to revoke probation is from April the 30th of 2026.
Okay.
Any other questions, sir?
Yeah, I mean, I've been able to keep in touch with him since I've been out. Like most of this time, I've been beat up, and they took all my phone and everything, and I've not been able to keep in touch with him. That's something. Like they stopped me today for falling asleep. Like I'm not trying to like avoid him. I'm gonna keep in touch with him. So I would
Understood,
prefer
sir.
to get a job and get back to that because I mean I was almost done with probation.
Understood, sir. If you wish to seek review of these release conditions, you may do so by motion, but that's going to be an issue for another day, sir. Thank you very much. Numbers 11 and 12 on the calendar, Ryan Short to the podium. Number 28 on the calendar, Matthew Mowry to the chair, please. And good evening, Mr. Short. Please tell me your name and date of birth.
Ryan Short, 05/22/94.
Thank you. We are here today on 2 cases. The first is a new case out of the Maricopa County Superior Court. The second is a bench warrant also out of Maricopa County Superior Court. As to the bench warrant, that was dated May the 1st of 2026, sir. There's 1 underlying count of narcotic drugs, class 4 felony, 1 underlying count of drug paraphernalia, class 6 felony. As to your new case, sir, there are 2 charges. The first is possession of narcotic drugs, class 4 felony. The second, possession of drug paraphernalia, a class 6 felony. I did find probable cause. As to both cases, sir, I'm going to appoint the public defender's office and set court dates for May the 18th and 20th of 2026. Both of those are at 8:30 in the morning at the downtown Superior Court complex. Now, I will note, as to your new case, it appears that, well, we have 2 cases here. In a prior case, the other matter, sir, the court did not find probable cause at the initial appearance, when you had initial appearance on that case, to hold you for the underlying offense, or offenses, I should say, in that matter. And so you were released with no probable cause found. Accordingly, I'm unable to find that you committed a new felony offense while on pretrial release for a separate felony charge. Therefore, I'm concluding that pursuant to the Arizona Constitution, you're eligible for bail in this case. And so bond is appropriate. I'm setting your bail at $1,500 on the new case, sir. That is a secured appearance bond with pretrial supervision and drug testing and monitoring. Treat pretrial supervision as a miniature probation that you're going to have to get in contact with and stay in contact with as the case moves forward. They're going to try and keep you on track with getting to your court dates and complying with your additional release conditions, which are mandatory drug testing and monitoring, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. As to your bench warrant matter, sir, I'm setting your bail at $250. That's noted, that's just the amount already set in the warrant, with other release conditions that will also be in writing for you, sir. Do you have any questions? All right, thank you, sir. Please step to your left. Number 28 on the calendar, Matthew Mowry to the podium, please. Number 22 on the calendar, Ignat Postnikov to the chair, please. And good evening, Mr. Mowry. Please tell me your name and date of birth.
8/15/79,
And your name, sir.
Matthew Mowry.
Mowry, all right, wonderful, thank you. We're here today on a new case out of the Maricopa County Superior Court. There are 3 charges, sir. The first is misconduct involving weapons, a Class 4 felony. The second, resisting arrest, a Class 6 felony. The third, failure to admit to carrying a deadly weapon, a Class 1 misdemeanor. I did find probable cause. I am appointing the Public Defender's Office to represent you, sir, and setting a status conference on May the 18th of 2026 at 8:30 in the morning at the downtown Superior Court complex, and a preliminary hearing on May the 20th of 2026, also 8:30 in the morning, downtown Superior Court. Sir, under the Arizona Constitution, you're eligible for bail. Therefore, I'm setting your bail at $10,000. That is a secured appearance bond. If you post bond, you'll be released, sir. If you are released, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Other release conditions will be in writing, sir. The written orders you're about to receive. Do you have any questions?
No.
All right, thank you very much. Please step to your left. Sorry? Oh, for our last matter? Oh, okay. All right. Do we have Mr. Kunkel yet? No? Okay. Number 22, Ignat Postnikov to the podium, please. Number 30 on the calendar, Dana Jeffries King to the chair, please. And good evening, Mr. Postnikov. Please tell me your name and date of birth.
Good evening, Your Honor. My name is Ignat Postnikov. My date of birth is 9 September 1998.
Thank you. We're here today on a grand jury warrant from the Maricopa County Superior Court. That means that a grand jury has found probable cause to hand down an indictment accusing you of 2 charges. The first, theft, a Class 3 felony. The second, aggravated taking of identification, a Class 3 felony, both alleged on or about January the 10th of 2026. I'm appointing the Public Defender's Office to represent you and setting an arraignment hearing for you on May the 19th of 2026 at 8:30 in the morning at the downtown Superior Court complex. Sir, under the Arizona Constitution, you are eligible for bail. Therefore, I'm setting your bail at $2,500. That is a secured appearance bond. If you post bond, you'll be released as to this case only. If you are released, do not have victim contact, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Other release conditions will be in writing in the written orders you're about to receive, sir. Do you have any questions?
No, sir.
Thank you very much. Please step to your left. Number 30 on the calendar, Dana Jeffries King to the podium, please. Number 15 and 16 on the calendar, Matthew Schneider to the chair, please. And good evening, Ms. Jeffries King. Please tell me your name and date of birth.
Dana Marie Jeffries King, August 11, 92.
Thank you very much. We're here today on a new case out of the Maricopa County Superior Court. Ma'am, there are 2 charges. The first is aggravated assault on a first responder, a Class 4 felony. The second is obstruction of a law enforcement officer, a Class 1 misdemeanor. I did find probable cause, and I am appointing the Public Defender's Office to represent you. Ma'am, I'm setting 2 court dates for you. The first is a status conference on May the 18th of 2026. That's at 8:30 in the morning at the downtown Superior Court complex. I'm also setting a preliminary hearing on May the 20th of 2026, also at 8:30 a.m. at the downtown Superior Court complex. Ma'am, under the Arizona Constitution, you're eligible for bail. I'm setting your bail at $2,000. That is a secured appearance bond. If you post bond, you'll be released. If you are released, do not have victim contact, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Other release conditions will be in writing in the written orders you're about to receive. Do you have any questions?
No.
Thank you. Please step to your left. Number 15 on the calendar, Matthew Schneider to the podium. Number 3 and 4 on the calendar, Vanna Apicito to the chair, please. And good evening, Mr. Schneider. Please tell me your name and date of birth.
Matthew Schneider, 9/26/92.
Thank you. We're here today on 2 cases, sir. These are both probation violation warrants out of the Maricopa County Superior Court. The Adult Probation Department has filed petitions to revoke your probation, alleging that you have violated terms 3 and 5 of probation. I'm appointing the Public Defender's Office to represent you and setting a combined probation revocation, arraignment, and disposition hearing on May the 18th of 2026 at 8:30 in the morning at the Downtown Superior Court Complex. Sir, under the Arizona Constitution, you're eligible for bail, setting your bail at $500 a case for a grand total of $1,000. That is a secured appearance bond. Sir, if you post bond, you'll be released. If you are released, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Contact your probation officer within 72 hours of your release. The release conditions will be in writing. The written orders you're about to receive, sir. Do you have any questions?
No, sir.
Thank you very much. Please step to your left. Numbers 3 and 4 on the calendar. Vanna Apicito to the podium, please. Number 7 on the calendar, Wilson Yazzie to the chair, please. Do we have Vanna Apicito? Thank you, ma'am. And good evening, Ms. Apicito. Please
Yes.
tell me your name and date of birth.
Ben Apetito, 51785.
Thank you. We're here today on 2 cases, ma'am. These are both probation violation warrants out of the Maricopa County Superior Court. The Adult Probation Department has filed petitions to revoke your probation, alleging that you have violated terms 3, 4, 5, and 15 of probation. I'm appointing the Public Defender's Office to represent you and setting a combined probation or revocation arraignment and disposition hearing on May the 18th of 2026 at 8:30 in the morning at the Downtown Superior Court Complex. I am affirming the bond amount already set in both warrants. That is $200 per case for a grand total of $400. That is a secured appearance bond. If you post bond, man, you'll be released. If you are released, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Contact your probation officer within 72 hours of your release. Other release conditions will be in writing in the written orders you're about to receive. Do you have any questions?
Am I going to get released?
If you post bail, you will be released. If you do not post bail, you will remain in custody pending your court date, ma'am.
Okay. I don't have no bail, no. How about reinstate my probation?
Well, that's the matter for the probation revocation, arraignment, and disposition hearing. That's on the 18th, ma'am.
Okay.
All right, thank you very much. Please step to your left.
Thank you.
Number 7 on the calendar, Wilson Yazzie to the podium, please. Number 10 on the calendar, Xavier Black to the chair, please. And good evening, Mr. Yazzie. Please tell me your name and date of birth.
Wilson Yazzie Jr., 09/27/1973.
Thank you. We're here today on a bench warrant from the Maricopa County Superior Court. The date of the bench warrant is listed as April the 27th of 2026. There are 2 underlying counts of aggravated driving under the influence, a Class 4 felony. I'm affirming the appointment of existing counsel and setting 2 court dates for you, sir. The first is a status conference on May the 18th of 2026. That's at 8:30 in the morning at the Downtown Superior Court Complex. The second is a preliminary hearing on May the 20th of 2026. That's at 8:30 in the morning, also at the Downtown Superior Court Complex. Sir, under the Arizona Constitution, you're eligible for bail. I'm setting your bail at $500. That's the amount already set in the bench warrant. Also ordering pretrial supervision with mandatory alcohol testing and monitoring. If you are released, do not possess or consume drugs without a valid prescription. Do not possess or consume any alcohol. Other release conditions will be in writing. Written orders you're about to receive, sir. Do you have any questions?
I was working. I finally got a job, and I was supposed to resume my payments this week too. And I had lost my class, the DD class, due to my insurance. I'm trying to fix. And then I finished my alcohol and drug class, but I was almost done with my DD class. So that's what's going on with me, and I'm on the street, and I have a job right now, but a side job I picked up by myself. I'm not employed, but I'm working in a time limit. I have like 4 more days to finish the job, but
Well, thank you for your input, sir.
I apologize, Your Honor.
And thank you for your input, sir. Most of my concern here, sir, comes from either your willingness or ability to attend court. So that's why I believe bond is appropriate. I'm not inclined to lower the bond or release you on your own recognizance. If you wish to seek review of the release conditions, you may do so by motion, but that is an issue for another day, sir. Thank you very much. Please step to your left.
Thank you, Your Honor.
Number 10 on the calendar, Xavier Black to the podium, please. Number 9 on the calendar, Rachel Chacon to the chair, please. And good evening, Mr. Black. Please tell me your name and date of birth.
Good evening, Your Honor. My name is Xavier Black, March 23rd, 2003.
Thank you. We are here today on an arrest warrant stemming out of a direct complaint from the Maricopa County Superior Court. There are 4 charges. The first 2 are aggravated driving under the influence, a Class 4 felony. There's also 1 count of false reporting to a law enforcement officer, a Class 1 misdemeanor. There's also 1 count of leaving the scene of a damage accident, a Class 1 misdemeanor, all alleged on or about May the 14th of 2023. Sir, I'm appointing the Public Defender's Office to represent you and setting 2 court dates. The first is a status conference on May the 18th of 2026. That's at 8:30 in the morning at the downtown Superior Court complex. The second is a preliminary hearing on May the 20th of 2026, also at 8:30 a.m. at the downtown Superior Court complex. Sir, under the Arizona Constitution, you're eligible for bail. Therefore, I'm setting your bail in the amount already set in the direct complaint warrant. That is a $500 cash-only appearance bond. Sir, if you post bond, you'll be released. If you are released, I'm ordering pretrial supervision through the Pretrial Services Agency with mandatory alcohol testing and monitoring. Additionally, if you are released, do not possess or consume drugs without a valid prescription. Do not possess or consume any alcohol. Other release conditions will be reduced to writing in the written orders you're about to receive, sir. Do you have any questions for me?
Well, I just wanted to tell you that, I tried going into the court this morning to squash my warrant, and they just ended up taking me in. The reason why I got that probation violation, I was going to classes. I paid my fine for the court, and I was going through hardship last year, and which had to cause me to move back home up north. I lived like 5 hours away, and I wasn't working. I couldn't afford my classes, and so finally I got a job out here, turning my life around. I'm a union iron worker, and this morning my wife dropped me off at the courthouse, hoping I'd squash it out, and they just took me in. So I'm here turning myself in, facing my consequences. I'm not trying to run or anything. I'm really trying to turn my life around, sir.
Well, thank you for your input, sir.
Yeah.
Most of my concern here comes from either your willingness or ability to come to court, and I do commend your efforts today, but the warrant being valid and standing being what it is, I'm not inclined to depart from that for the time being. If you wish to seek modification of the release conditions, you may do so by motion, but that's going to be an issue for another day, sir.
Okay.
All right?
So I could post bail at 500?
500, yes.
Okay. Thank you, Your Honor.
Thank you, sir. Number 9 on the calendar, Rachel Chacon to the podium, please. And number 5 on the calendar, David McKelvey to the chair, please. And good evening to all counsel. And good evening, Ms. Chacon. Please tell me your name and date of birth.
It's Chavez, actually. They made a typo error.
I'm sorry?
They made a typo error. It's actually Chavez.
Chavez.
C-H-A-V-E-Z.
Okay. Still Rachel Yvonne, but last name Chavez?
Yes.
Okay. Give me just a moment. C-H-A-V-E-Z, you said?
Mm-hmm.
All right. That should save. All right. We're here today on a municipal court new case from the Goodyear Municipal Court. There is one charge of shoplifting, a misdemeanor, one charge of drug paraphernalia, also classified here as a misdemeanor. I did find probable cause, and I am going to set a court date for you on May the 27th of 2026 at 1:00 p.m. at the Goodyear Municipal Court. Given the nature of the allegations, I'm not appointing counsel to represent you. You may retain counsel at your own expense if you wish to do so. Again, your court date is May 27th of 2026 at 1 p.m. at Goodyear Municipal Court. Do you promise to appear?
Yes, sir.
Based on your promise to appear, it's ordered releasing you on your own recognizance. If you fail to appear for a court date, a warrant will issue for your arrest. Additionally, as you are released, do not return to the scene of the alleged crime. Do not have any victim contact. Do not possess or consume drugs without a valid prescription. Do not possess or consume any alcohol. Other release conditions will be in writing in the written notice you're about to receive, ma'am. Do you have any questions for me?
No.
Thank you. Please step to your left.
Thank you.
Number 5 on the calendar, David McKelvey to the podium, please. Number 6 on the calendar, Addison Katrinik to the chair, please. Number 6 is going to be a reprint. It's one of those issues with appointment of counsel. So I'll just fix that real quick. All right, Mr. McKelvey, thank you very much. Please tell me your name and date of birth.
David Junior McKelvey,
And what's your birthday, sir?
9/16/82.
Thank you very much. We're here today on a probation violation warrant from the Maricopa County Superior Court. The Adult Probation Department alleges that you have violated terms 3 and 5 of probation in a petition to revoke your probation. This is also a reprint. Give me just a moment, sir. Sir, I'm appointing the Public Defender's Office to represent you and setting your court date for a combined probation revocation arraignment hearing and disposition hearing on May the 18th of 2026 at 8:30 in the morning at the downtown Superior Court complex. Sir, I'm setting your bond in the amount of $650. That is a secured appearance bond. If you post bond, to be released. If you are released, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Contact probation within 72 hours of your release if you are released. Other release conditions will be in writing in the written orders you're about to receive, sir. Do you have any questions for me?
Yes, sir. You think I get a bail reduction? Because like my family is going through hard times right now.
Well, sir, one of my concerns here is that there are allegations that you're not keeping in touch with the Adult Probation Department, and by proxy, I have concerns about your willingness or ability to come to court. So I do believe that bond is appropriate. If you wish to seek bond reduction or bond modification, you may do so by motion, but that's going to be an issue for another day, sir. All right? All right, thank you very much, sir. You may step to your left.
All right, because I was in a halfway house.
All right, thank you, sir. Number 6 on the calendar, Addison Katrinik to the podium, please. Number 20 on the calendar, Leonard Bills to the chair, please. And good evening, Ms. Katrinik. Please tell me your name and date of birth.
Addison Katrinik, March 14, 2005.
Thank you. We're here today on a new case out of the Maricopa County Superior Court. There's one charge of unlawful flight from a law enforcement vehicle, a Class 5 felony. I did find probable cause, and I'm appointing the Public Defender's Office to represent you. Ma'am, you have 2 court dates coming up on May the 26th and 29th of 2026. Both of those are at 8:30 in the morning at the downtown Superior Court complex. Do you promise to appear?
Yes.
Based on your promise to appear, it's ordered releasing you on your own recognizance. If you fail to appear for a court date, a warrant will issue for your arrest. Additionally, as you are released, do not possess or consume drugs without a valid prescription. Do not possess or consume any alcohol. Do not drive a motor vehicle without a valid driver's license. Other release conditions will be reduced to writing in the written orders you're about to receive. Do you have any questions for me?
No.
All right, thank you very much. Please step to your left. Number 20 on the calendar, Leonard Bills to the podium, please. And number 2 on the calendar, Brianna Kerr to the chair, please. And good evening, Mr. Bills. Please tell me your name and date of birth.
Leo Bills, 7/13/78.
Thank you. We're here today on a new case out of the Maricopa County Superior Court. There are 2 charges. The first is possession of dangerous drugs, a Class 4 felony. The second is possession of drug paraphernalia, Class 6 felony. I did determine probable cause that I am appointing the Public Defender's Office to represent you. Sir, I'm setting 2 court dates for you. The first is a status conference at the Downtown Superior Court on May 26, 2026 at 8:30 a.m. The second is a preliminary hearing, also Downtown Superior Court, May the 29th of 2026, 8:30 a.m. Do you promise to appear? Is that a yes, sir?
Yes.
All right. Based on your promise to appear, it's order releasing you on your own recognizance. If you fail to appear for a court date, a warrant will issue for your arrest. Additionally, as you are released, do not possess or consume drugs without a valid prescription. Do not possess or consume any alcohol. Other release conditions will be reduced to writing, sir, on the written orders you're about to receive. Do you have any questions for me? Thank you, sir. You may step to your left. Numbers 1 and 8 on the calendar. Jihad Majid Ahad to the podium, please. And good evening, sir. Please tell me your name and date of birth.
Jihad Majid Ahad, 8876.
Thank you. We're here today on 2 cases. The first is a new case out of the Maricopa County Superior Court. The second is a probation violation warrant issued out of Maricopa County Superior Court alleging a Term 1 violation. Term 1 of probation, as we know, is do not commit new criminal offenses while out on on adult probation, I should say. And we have a new criminal submission here. There are 2 charges on the new submission, sir. First is promoting prison contraband, a Class 2 felony. The second is possession of drug paraphernalia, a Class 6 felony. Given the allegations in the Form 4 in the arrest narrative, I found insufficient information for probable cause as to the alleged pipe as contraband as defined by ARS 132501. Additionally, without further information, the court was unable to determine probable cause regarding drug paraphernalia per ARS 133415. So here's what that means and here's what that doesn't mean, sir. It means that for today's purposes, I'm releasing you. What it doesn't mean is that the prosecution still couldn't go forward in the event that the state thought it had enough evidence to secure a conviction against you, okay?
Yes, sir.
So the moral of the story, sir, is you still have to go to court. I'm setting your court dates on the first case, as I said, May 26th and 29th of 2026, 8:30 a.m. at the Downtown Superior Court. If you fail to appear, a warrant will issue for your arrest. As to your probation violation matter, your court date is May the 18th, scratch that. Actually, no, that's right. May the 18th of 2026 at 8:30 a.m. Downtown Superior Court. Do you promise to appear?
Yes, sir.
Based on your promise to appear, it's order releasing you on your own recognizance on the probation violation matter. As you are released, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Contact probation within 72 hours of your release, sir. Other release conditions will be in writing in the written orders you're about to receive. Do you have any questions for me, sir?
No, sir.
Thank you. Please step to your left.
Thank you.
Let's clear gallery for our remaining 2 matters, and then we'll move to the last matter on the calendar. Officer, can we clear the gallery, please? Yes, sir.
Your Honor, would you want to do Brianna Kerr before we clear the gallery?
You know what? I would.
Thank you, Your Honor.
All right. Ms. Kerr, please approach the podium. All right, good evening, Ms. Kerr. Please tell me your name and date of birth.
Brianna Ray Kerr, November 19, 1995.
Thank you. We're here today on a new case out of the Buckeye Municipal Court. There are two charges. The first is assault, a Class 1 misdemeanor. The second is disorderly conduct, also a Class 1 misdemeanor. I did find probable cause. Given the nature of the charges, I am not appointing counsel. You may retain counsel at your own expense if you wish to do so. Now, your next hearing is May the 26th of 2026. That's at 2:00 p.m. at the Buckeye Municipal Court. Do you promise to appear?
I do.
Based on your promise to appear, it's ordered releasing you on your own recognizance. If you fail to appear for a court date, a warrant will issue for your arrest. Additionally, as you are released, do not have victim contact, do not reside at the same location as any alleged victim, and do not go to the alleged victim's residence. In the event that you reside with the alleged victim, you must find an alternative residence and bring proof of that to your next court date. Additionally, if you need to gather essential belongings, one civil standby with a law enforcement officer present is allowed. Additionally, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. You must obey the terms of any order of protection or injunction against harassment that is issued or to be issued and served upon you. Other release conditions will be reduced to writing in the written notice you're about to receive. Do you have any questions for me, ma'am?
Am I able to go get my car from the residence with an officer present?
As I noted, one civil standby with a law enforcement officer is present is allowed, yes.
Okay.
So you're going to have to get in contact with a law enforcement agency to arrange that, ma'am.
Okay, thank you.
All right, thank you very much. Please step to your left. Okay, now we can clear the gallery. We're clear?
Clear, Your Honor.
Okay, wonderful. Good evening, Mr. Chavez. Please tell me your name and date of birth.
Angel Chavez, Angel Javier Chavez, March 1st, 1990.
Thank you. We're here today on two cases. The first is on a direct complaint warrant from Maricopa County Superior Court. The second is a probation violation warrant also out of Maricopa County Superior Court alleging a Term 1 violation. Term 1 of probation, as we know, is do not commit new crimes while out on probation, so we have a new submission here. On the new submission, we have one charge of possession of narcotic drugs, a Class 4 felony. There's one count of possession of drug paraphernalia, a Class 6 felony, both alleged on or about February the 20th of 2026. I'm appointing the Public Defender's Office to represent you as to both cases. As to the new case, sir, I'm setting your court dates on May the 18th of 2026 and May the 20th of 2026, both at 8:30 in the morning at the Downtown Superior Court Complex. That's a new case, sir. Under the Arizona Constitution, you're eligible for bail. Therefore, I'm setting your bail at $1,500. That is a secured appearance bond with other release conditions that will be reduced to writing in the written notice that you'll receive. However, as to the probation violation matter, at this time, pursuant to Arizona Rule of Criminal Procedure 7.2C, I'm ordering that you be held without bail. Do you have any questions, sir?
So that means I'm not getting released?
As to the probation violation
14th?
matters, yes. As to the probation violation matter, I'm ordering that you be held without bail, yes.
Okay.
Do you have any other questions, sir?
No.
All right, thank you very much. You may step to your left. All right, we have one remaining matter. My understanding is that the sheriff's office is going to bring her into the courtroom. Is that still correct?
Yes, Your Honor.
Okay, we'll go ahead and wait for Ms. Garcia to arrive.
And then, Your Honor, is defense counsel going to be on Teams or?
He is on Teams. Is the monitor not on?
No.
Okay, can we get that on? Okay, thank you. just get the monitor up and running. What's that? Oh, okay. Yeah, that's fine. No problem. There we go. Okay. All right. This is the time set for initial appearance for number 21 on the calendar, Eva Garcia. Ms. Garcia, please approach the podium in the middle of the courtroom, and counsel please announce.
Christina Wallace on behalf of the state.
Good evening, Your Honor. Stephen Kunkel from the Building Law Firm on behalf of Ms. Garcia.
Thank you. Before we get started, I'll note that extraordinary circumstances were found pursuant to State versus Brown, 233 Arizona, 153, Appeals 2013, regarding presentment based on the information from the arresting agency, I should say. The defendant's need for medical care prevented initial appearance within 24 hours, I should say. So proceed with the initial appearance now. Ms. Garcia, please tell me your name and date of birth.
My name is Eva Garcia, and my date of birth is 05/25/2002.
Thank you very much. We're here today on a new case. There are 8 charges. And before I go through the listing of the charges, both counsel, reading count 1 as an attempted murder in the first degree based on my reading of ARS 13-1001. It was submitted as a Class 1, but based on my understanding of ARS 13-1001, that's going to be a Class 2. Is that correct?
That is correct, Your Honor.
And thank you. And as to the, it doesn't really specify as to which aggravated assault charge is attributable to which victim. I did note that one of the alleged victims here was a civilian. And so, based on my reading of ARS 13-1204, one of these aggravated assault charges is a Class 3 felony as opposed to the submitted Class 2. Is that correct?
Correct.
Your Honor, I note down below, I think it's, there's 3 counts of aggravated assault. If I read this correctly, there was an officer, a civilian, and an employee. I don't know if the employee would count as a Class 2. But I did note there's another Class 3 down below.
Okay, I'll reserve that for arguments on probable cause, Mr. Kunkel.
Yeah.
Ms. Garcia, we have 8 counts, as I said. There's 1 count of attempted murder in the first degree, a Class 2 felony. There are 2 counts of aggravated assault, a Class 2 felony. There's 1 count of kidnapping, Class 2 felony. There's 1 count of aggravated assault, a Class 3 felony. There are 3 counts of disorderly conduct with a deadly weapon or dangerous instrument, a Class 6 felony. I'll now hear argument on probable cause, if any, from either counsel.
No, Your Honor, I don't have any argument on probable cause. I believe the Form 4 speaks for itself.
And nothing from the state, Your Honor.
The court will make findings for probable cause as to all counts. Mr. Kunkel, I noticed your notice of appearance. Was that just for the purpose of tonight, or was that for a general notice of appearance moving forward?
It's for moving forward at this point, Your Honor.
Very well. So I'm going to edit the council order. The council order will reflect the appearance of Stephen Kunkel as attorney of record. Ma'am, you have two court dates coming up. The first is a status conference on May 18th of 2026. That's at 8:30 in the morning at the downtown Superior Court complex. The second is a preliminary hearing on May the 20th of 2026 at 8:30 in the morning at the downtown Superior Court complex. Before I hear argument as to release conditions, I will note that I did receive a written recommendation from the state. And I'll pull that up now. I'm reading the state's recommendation, and pardon me if I'm getting ahead of myself. I'm reading the state's recommendation as 1 million cash-only appearance bond. Now, based on my experience with charges being filed by your office, it's my experience that bond in this level is typically requested on homicide cases that are not inchoate offenses and not preparatory offenses. So while I am inclined to, and I do believe that bond is appropriate and cash bond is appropriate, and I do believe that perhaps a substantial cash bond is appropriate, from the state, what I'm most interested in is what I see as a departure from the norm for an inchoate offense of attempt. So if the state would focus its argument on that, the court would appreciate that. Thank you.
Yep. Are you ready for this?
Of course, yes. Thank you very much.
Your Honor, this was a premeditated offense. The suspect drove down to the police station. She walked in with her backpack. She stared at the wall for a moment, thinking about what she was going to do, and then she pulled out a gun inside the lobby of the police station. This was all on surveillance video. The surveillance video shows that her demeanor was calm. She was calculated. She started by pointing a handgun at the police aide who was acting as a receptionist. She then moved and pointed a handgun at a civilian who was in the lobby. She forced him down to his knees at gunpoint. She was then told by officers to drop the gun that she had in her hand. She responded to that by attempting to shoot them. She pulled the trigger at least once. The surveillance video shows that she then tried to clear the gun at least 2 times because it jammed. And she then pointed the gun at officers again. The gun jamming might be the only reason why an officer wasn't killed. While only one officer was at the door, there were a line of officers behind him, and those officers were in the line of fire should the suspect have been able to fire her gun. The apparent trigger for this incident was a breakup that the suspect had with her boyfriend the night before. The suspect has shown that she is willing to point a gun not only at an innocent person in the lobby, at the receptionist at the window, but what is the most terrifying and I believe justifies the $1 million cash-only bond is that she walked into a police station and was willing to pull the trigger of her gun pointed at a line of armed officers. Given the egregious nature of the suspect's actions, a $1 million cash-only bond is necessary to protect the community. Thank you.
And Mr. Kunkel.
Your Honor, with all due respect to the state's argument, the purpose of bond is to ensure that Ms. Garcia returns to court. What I hear being somewhat bootstrapped in there with the state's argument is that Ms. Garcia, in the state's estimation, is a danger to the community. There's a lot going on here, Your Honor, behind the scenes, obviously, for someone to walk into a police station and take these alleged actions. Ms. Garcia, as she stands before you, just finished a stint in the hospital, she had a wound to her lower abdomen, a gunshot wound, where she was shot. And I believe in that injury is the context that I'd ask this court to consider in evaluating the amount of bond that you may impose and whatever, and I'd like to address other possible release conditions. Ms. Garcia, she stands there before you, Your Honor, a long history of interventions and treatments and healthcare. I was on the phone earlier this afternoon with a representative from Southwest Network about getting her back into obtaining services again. It's a tale Your Honor's probably familiar with, where individuals, they have difficulties, if you will, living up to their obligations to ensure they get and keep up with their own treatment. And that's what Ms. Garcia needs, is treatment. I understand there's a necessity here for bond, perhaps, that, to ensure her return to court. But what we're trying to do is get her hooked up with possibly a living situation again through her healthcare providers where she can get treatment. Someone doesn't walk into a police station and engage in that kind of behavior as badly as she did it. And I think that the $1 million cash bond, I think that's just over the top. If there's a sense of outrage, it should be asking for that kind of bond from essentially somebody who's indigent standing before you. That's just a bond designed to punish somebody, to be punitive. That's not to ensure her return to court. And, Your Honor, I'd submit that that's not it's conflating a perceived danger. She's more of a danger to herself here than anything else. It's unfortunate what happened, and it's fortunate that other people were not hurt. But I think if Your Honor looks into this Form 4, you'll see what was really going on with Ms. Garcia and where her intentions may have been. I'd ask you to impose a reasonable bond. I'd ask that if you're worried about her being a danger to the community, if she were to be released, and I understand from speaking to the supervisor I spoke with at Southwest Networks, they will be trying to see her in the next day or two to get her arranged again for services, for her treatment, for SMI treatment. And I'd ask you to impose a bond that reflects enough of the severity of the offenses to ensure a return to court. That's it. But the state's argument is really too much, and it's over the top. I have nothing further.
Thank you, Mr. Kunkel. Anything further from state?
Yes, Your Honor. The state would just like to point out that the defense counsel mentioned that the focus should be on whether the defendant is going to appear again, but the statute that lists all of the factors that the court should consider specifically states that the court is also to consider the danger the defendant poses to the community, the nature of the offense, the weight of the evidence. So there is more to be considered by this court than just whether or not the defendant is going to appear at the next hearing. Additionally, the state would, there's little that is more dangerous than a person who is willing to walk into a police station armed, pull out that firearm, and then point it at police officers. So, and at this point, the court is essentially asking to put a price on the safety of the community. This was a very egregious offense. This was premeditated. She went to the police station in her car. She had her gun in her backpack. She walked in, she thought about it, and she pulled out the firearm, not only pointing at police officers, but at a civilian and the receptionist as well. So for those reasons, the state believes that a $1 million cash-only bond is appropriate in this case.
All right. Thank you to all counsel for your arguments. I will note, pursuant to Arizona Rule of Criminal Procedure 7.2A2, one of the purposes of bond under the under Rule 7.2, and Mr. Kunkel is correct, one of them is to assure the defendant's appearance, but some of the other considerations are victim safety and community safety, which this court is duty-bound to observe. And so, pursuant to, again, Arizona Rule of Criminal Procedure 7.2A2, the defendant must be released on her own recognizance unless additional release condition is reasonably necessary to assure appearance, protect victims, other people, or the community from harm or necessary. If the court makes such a determination, it must impose the least onerous conditions of release necessary to accomplish those goals. The court has considered the arguments of both counsel. The court's also considered the nature of the charges, most specifically the preparatory offense of attempted murder in the first degree and the inchoate nature of that offense, which the court believes is relevant to what it has to consider as the nature of the allegations. The court's also considered the allegations in the Form 4 and is supplemented by counsel for the state. The court's also considered the defendant's lack of criminal history as was reported by the Pretrial Services Agency. The court did not see any arrest or conviction history alleged in the Form 4. The court's not missing any prior arrest history or conviction history. There was none, correct?
No, Your Honor.
Okay. Likewise, the court's also considered the suggestion from the Pretrial Services Agency's risk assessment that bond is appropriate. Given all of this, and based on the arguments of counsel, the court also believes that mental health may be a consideration in this case, so the court is also duty-bound to consider. Given the nature of the charges and the weight of the evidence, especially the allegation that the defendant is alleged to have pulled the firearms trigger and that it did not discharge but for the malfunction, the court concludes that a substantial cash bond is appropriate in the interest of victim and community safety. Therefore, based on the court's duty to impose the least onerous bond reasonably necessary in this case, the court will set bail in the amount of $850,000. That is a cash-only appearance bond. The court's also ordering pretrial services supervision with mandatory electronic monitoring to be installed before released. Additionally, ma'am, if you are released, do not return to the scene of the alleged crime, do not have victim contact, do not initiate contact with any alleged complainant or witness, do not initiate contact with any arresting officer, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol, do not drive a motor vehicle without a valid driver's license, do not leave the state. You must notify the court of any new address, you must submit to DNA testing, and you must submit to 10-print fingerprinting from the arresting agency. The court will assign these release conditions now. Anything further from either counsel?
No, Your Honor.
Mr. Kunkel.
No, Your Honor. Thank you for allowing me to appear virtually this evening. Thank you.
Of course, and thank you to all counsel for your patience as we work through the calendar tonight. I do appreciate your patience. We'll be adjourned on number 21, Ava Garcia. Ms. Garcia, thank you. You may step to your left.
Thank you.
That brings us to the end of the 5:00 p.m. initial appearance calendar for May the 11th of 2026. We will stand in recess.
$15,000. Did you want to be heard?
No.
No, your
That's
lawyer.
Judge, yes, I want to be heard on probable cause first, at least to the burglary tools, and theft counts.
Yeah,
Did you see that too?
I did.
Yeah. I don't think there's any ID there, probable cause for ID, so I'd move to dismiss those, and then just that there's 2 counts then in front of you. I'd be asking for no more than a $2,500 bond.
Okay, well, I think that that we've decided that the rules say that I have to release when I find no probable cause, but not dismiss. So, I will, put down that there's no probable cause on. So you think that there's the theft and the trafficking is good enough from
I
the,
just think the trafficking and stolen property, 2 counts of that.
okay. Yeah, I thought it was kind of a statement rather than a probable cause statement, so I agree. Tools, or does the state want to be heard on the bond? I mean, I think I have to release the defendant on the charges where I don't find any probable cause.
Thank you, Your Honor. Obviously, the state doesn't necessarily agree there's not probable cause on those counts, but of course we'll submit to the court on what the appropriate course of action is there, and would emphasize the trafficking counts still, I believe, clearly have probable cause.
Okay. I'm gonna hold Mr. McCurdy on a $5,000 bond on those counts, basically, and appoint the legal defender to represent him, no contact with the victims, no return to the incident locations, no alcohol or illegal drugs. If the bond is posted, released to pretrial services, and the preliminary hearing will be May 21st at 1:30. And that's it.
Judge, just so you know, your video isn't on.
Oh, it's not? Huh, it was to start, but you're right, it's not anymore. I saw myself when we first started. Thanks. Let's see if we can fix that.
Go ahead.
Excuse me, Your Honor.
Yeah,
To now Muir, he refused.
hasn't he refused like 300 times? Yes. Counsel, do you want to waive his presence? And we want to waive his appearance since he has keeps refusing and he's there anyway?
Can I just check how many times he's refused?
Yeah, I think I exaggerated. While you're checking, we're gonna have to turn this off and we'll sign back on again so we can see if we can find my video, okay? Yeah, we were there when we started. Yeah, there I am. Okay. So I think he's refused like twice or 3 times.
I think this would be his 3rd refusal. So I'm okay waiving his presence, mostly because he's already being held without bond.
Yeah, that's why I figured it wasn't a big deal. Okay. And then state is asking for a $10,000 bond, but he's got a probation hold, is that right?
It looks like a federal hold.
Oh, okay. All right, so 10,000, what's the defense argument here?
Judge, given all the holds and the nature of the charges, I don't think it needs to be that high. So we are asking for a bond, but something lower than the 10,000.
Okay. Yeah, I am going to appoint the public defender and no alcohol or illegal drugs and a $2,500 bond. And then the preliminary hearing will be the 21st at 1:30. Okay, thanks.
Father Roscoe, come up and have a cigarette with me.
What's your name, sir?
Scott Roscoe.
All right. You are charged with domestic violence violation of an order of protection. And I am going to order you not to have any contact with Miss Bianchilli, no return to her residence or work. I'm going to appoint Adam Waters to represent you. No acts of domestic violence. You have any guns? What? Do you have?
No.
You have no guns? No guns, no alcohol or illegal drugs. I'm gonna hold you on a $1,000 bond. And your next court date will be tomorrow at 1 p.m. And that's it, sir.
We're going down the stairs. Giddings? Come on, sit here. Right.
What's your name?
Jackie Giddings.
All right, you're charged with domestic violence assault, domestic violence unlawful imprisonment, and domestic violence disorderly conduct. I am going to order you not to consume or possess any alcohol or illegal drugs, and no acts of domestic violence, and you need to come back to city court on June 2nd at 1:30, or a warrant will issue for your arrest. You understand?
Yeah, so what does that mean? My question, am I getting housed too?
No, I'm releasing you on your promise to not consume any alcohol or illegal drugs and not commit any acts of domestic violence, and your promise to come to court, or we'll issue a warrant if you don't.
Yes, ma'am.
Okay. See you June 2nd.
Thank you.
All right.
Right here? Yep.
All right. What's your name, sir?
David William Tarico.
All right. Counsel, you waiving the reading of the charges?
Yes, Judge.
The state's asking for a $5,000 bond. Did you want to be heard?
Yes, Judge. It looks like he has verified housing, and support with his son. He is also verified disabled. This prior that, requires this, yearly registration is from 1994, and it doesn't appear he's had any new offenses since, including no failures to register. So for those reasons, we're asking you give him a chance on release, to go take care of this.
All right. I will appoint the public defender to represent Mr. Carrico, order him released to pretrial services, and you need to report to the sheriff's ID unit within 72 hours of release, and report to pretrial services. And your next court date will be June 1st at 1:30. So make sure you're in touch with your attorneys and do all that. All right?
Very good. Thank you.
Do you talk to your clients, or do I need to read them the STEPS project?
You'll have to read it, Judge.
I'll have to read it? Okay. I tried. What's your name, sir?
Sergio Escobar.
You are charged with possession of a narcotic drug. You may be eligible to participate in a diversion program called STEPS that requires you to participate in a plan specific to your needs for a short time. If you choose to participate and complete the program, these felony drug charges will be permanently dismissed without you ever being formally charged. Are you interested in that program?
Very interested.
Okay. But, however, I will appoint the public defender, order the defendant to possess or consume no alcohol or illegal drugs, set the steps hearing for May 18th at 9 a.m., but the state is asking for either no bond or 15,000 are your choices, counsel. Which would you pick?
Well, Judge, I'm a little confused because the pretrial services report that I'm reading shows he has no priors.
Yeah, I was thinking that too. I was thinking there was another guy like that, but not this one.
Yeah, and that was my mistake, Judge. I
Okay.
apologize. So state's not asking for no bond. Sorry for that mistake. State believes a $2,500 bond would be appropriate.
Okay. All right. Well, everybody else that we put on steps gets to chance to get out, and he does not have any priors. So I am going to give him a chance to get out and report to steps and say, and then you'll waive time on the preliminary hearing, counsel?
Yes, Judge.
Okay. So, sir, you need to show up for your steps hearing May 18th at 9 a.m. You need to report to pretrial services because that's who I'm going to release you to. And then your other court date will be your preliminary hearing on June 25th. But you need to stay in touch with your attorney. The important date is that May 18th one, okay?
Okay.
All right. That's what we will do.
All righty. Thank you, guys. Thank you, Your Honor.
Okay.
Hi,
What's your name, sir?
Carlos Perez,
All right. What's your date of birth?
3/12/1979.
Okay. So you are charged with robbery, and the state's asking for a $50,000 bond. Counsel, you want to be heard?
Judge, I'm asking for something much less than the 50,000. I don't have any verified employment at this time, and it looks like the interim complaint is very unclear on what exactly happened. They just say assault, so I don't know what that means. It was over $6.50. So
Sure, $1.
been all that, Your Honor, we're asking for something much less if you are inclined for a bond.
Well, they didn't charge him with assault, which I thought was weird too. So, right, he's charged with robbery. So, I am going to appoint the public defender, order the defendant not to have any contact with the victim, not to go to the incident location, no alcohol or illegal drugs. I'm going to hold him on a $5,000 bond, pretrial services if posted, and the preliminary hearing will be May 21st at 1:30.
All rise.
Thank you. Please be seated. This is the 8 o'clock p.m. initial appearance calendar for May the 11th of 2026. The court's orders for the taking of DNA and fingerprints that were given on the first calendar date of this month shall apply to all matters on this calendar. I will now read the victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present in court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. Ladies and gentlemen, we are here today for an initial appearance calendar. What that means is that you're going to hear a little bit more about the allegations against you, whether or not you've been appointed counsel, your next court dates, and your release conditions. As I call you up, please approach the podium that is in the center of the courtroom right over here. If you are next, please sit in the chair that is next to the front door of the gallery. We'll get started with numbers 6 through 8 on the calendar. Alvin Rude to the podium, please. And number 17 on the calendar, James Spites to the chair, please. And good evening, Mr. Rude. Please tell me your name and date of birth.
Alvin Rude, 2/16/82.
Thank you. Sir, we're here today on 3 cases. The first is a new case from the Maricopa County Superior Court. The other 2 are, well, one is a bench warrant from Maricopa County Superior Court dated March the 12th of 2026. Last is a probation violation warrant stemming from a failure to appear. That appears to be from March the 12th of 2026. In any event, sir, on your new case, there are 2 charges. The first is possession of narcotic drugs, a Class 4 felony. The second is possession of dangerous drugs, a Class 4 felony. I did find probable cause. I am appointing the Public Defender's Office to represent you in all 3 of your cases. As to court dates, sir, your next court dates are, I'll pull those up, May the 15th, 18th, and 20th of 2026. All of those, except for one, are at 8:30 in the morning. On the 18th, you have an evidentiary hearing at the Downtown Superior Courthouse at 1:30 p.m. As to the bench warrant matters, I am affirming the bond amounts in the warrants. That's $1,000 apiece, secured appearance. However, as to the new case, because there's an allegation that a new felony offense was committed while out on felony release for a prior felony case, Arizona law prohibits me from admitting you to bail at this time. Therefore, I'm ordering that you be held without bail on your new case pending the evidentiary hearing on the 18th, sir. Do you have any questions?
No.
Thank you. Please step to your left. Number 17 on the calendar, please, James Spites. And good evening, Mr. Spites. Please tell me your name and date of birth.
Who?
Please tell me your name and date of birth, sir.
James Spates, 4/12/91.
All right, Spates, thank you. We're here today on a new case from the Maricopa County Superior Court. There are 4 charges. The first, aggravated assault, a Class 3 felony. The second, unlawful imprisonment, a Class 6 felony. Third, threatening or intimidating, a Class 1 misdemeanor. Finally, preventing the use of a phone in an emergency, a Class 2 misdemeanor. I did find probable cause, and I am appointing the Public Defender's Office to represent you. Sir, you have 2 court dates coming up. The first is on May the 18th of 2026 at 8:30 in the morning for a status conference. The second is a preliminary hearing on May the 20th of 2026 at 8:30 in the morning. Both of those are at the Downtown Superior Court complex. Sir, under the Arizona Constitution, you're eligible for bail. Therefore, I'm setting your bail at $75,000. That is a secured appearance bond. If you post bond, you'll be released. If you are released, I'm ordering pretrial services supervision with mandatory electronic monitoring to be installed before you are released. Additionally, if you are released, do not have victim contact, do not reside at the same location as any alleged victim, and do not go to the alleged victim's residence, even if you're an owner or renter of that residence. If you reside with any alleged victim, you must find an alternative residence and bring proof of that to your next court date. In the event that you need to gather essential belongings, one civil standby with a law enforcement officer present is allowed. Additionally, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. You must obey the terms of any order of protection that is issued or injunction against harassment that is issued or to be issued and served upon you. Other release conditions will be in writing. The written orders you're about to receive, sir. Do you have any questions?
Yes. I never been a type to call law enforcement, and you can see in my hand, I got stabbed in my hand. You know what I'm saying? And I didn't do nothing. I did the right thing. I called the officer, whatever, and then they took my son's mom's word over my word, and I'm the one who initiated the phone call. And I felt like that was wrong on the law enforcement end because they didn't take what I had to say in consideration. And by me being a guy, they took her word over mine, and I feel like I really didn't do nothing wrong besides call law enforcement to help me and help my wound. It was blood everywhere all over my hand. I got stabbed because I'm going through a breakup. I told her I didn't want to deal with her no more. She pulled a knife out and stabbed me.
Well, sir, and thank you for your input. I do appreciate your input. It sounds like you may have some questions or some issues with the underlying allegations on the case. I have appointed counsel for you, so my suggestion is to direct those questions to counsel. For tonight's purposes, sir, I'm not inclined to revisit the release conditions. If you wish to seek review of the release conditions, you may do so by motion, but that's going to be an issue for another time, sir.
Okay, so do I? So that in order to get out, I have to post bail.
If you post bail, yes, you'll be released. Yes.
And if I don't post bail, I'll be here to my next court date.
If you do not post bail, you'll be held in pretrial custody. Yes.
Okay.
All right. Thank you, sir. Number 22 on the calendar, Glenn Laneza to the podium, please. Number 14, Adolfo Lazama to the chair, please. And good evening, Mr. Laneza. Please tell me your name and date of birth.
Glenn Yaneza, 12084.
Okay, Yaneza. All right, thank you.
Yes, sir.
We're here today on a new case, sir. This is out of the Maricopa County Superior Court. There are 2 counts of theft, a Class 3 felony, for which I did find probable cause. I'm appointing the Public Defender's Office to represent you, sir. You have 2 court dates coming up. The first is a status conference on May the 18th of 2026. That's at 8:30 in the morning at the Downtown Superior Court Complex. The second is a preliminary hearing on May the 20th of 2026. That's at 8:30 a.m. at the Downtown Superior Court Complex. Sir, under the Arizona Constitution, you're eligible for bail, so I'm setting your bail at $15,000. That is a secured appearance bond. If you post bond, sir, you'll be released. If you are released, do not return to the scene of the alleged crime. Do not have any victim contact. Do not possess or consume drugs without a valid prescription. Do not possess or consume any alcohol. Other release conditions will be reduced to writing in the written orders you're about to receive, sir. Do you have any questions?
Your Honor, I did it, and I'm really sorry. I shouldn't have done it.
Well, sir, before you go further, you may have heard this during the group advisement. You do have the right to remain silent. Anything that you say can be used against you. Okay. You'll notice, as I said, that I already determined probable cause for the alleged offenses. Of course, I don't want to disparage the presumption of innocence here. However, most of what I'm doing now that I've determined probable cause is determining release conditions. So most of what I'm interested in at this point has to do with release conditions. So if you're going to say anything, that's mostly what I'm interested in, but I don't want to get in the way of anything you want to tell me. Did you have any questions, sir?
No, sir. Thank you.
All right. Just to reiterate, again, do not return to the scene of the alleged crime. Do not have victim contact. do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Other release conditions will be in writing that you'll be provided, sir. Anything else?
That's it, Your Honor.
Okay, thank you very much.
Thank you.
Oh, other way, sir.
That's all right.
All right, thank you. Number 14 on the calendar, Adolfo Lizama to the podium. Numbers 15 and 16 on the calendar, Mariah Espinoza to the chair, please. And good evening, Mr. Lizama. Please tell me your name and date of birth.
Adolfo Lizama, December 23rd, 1990.
Thank you very much. We're here today on a new case out of the Maricopa County Superior Court. There are 3 charges. The first 2 are aggravated driving under the influence, a Class 4 felony. The third is driving with a suspended license, a Class 1 misdemeanor. I did find probable cause, and I am appointing the Public Defender's Office to represent you. Sir, you have 2 court dates coming up. The first is a status conference on May the 18th of 2026 at 8:30 in the morning. The second is a preliminary hearing on May the 20th of 2026. That's also at 8:30 in the morning at the Downtown Superior Court complex. Sir, under the Arizona Constitution, you're eligible for bail. That means I'm going to set your bail at $1,000. That is a secured appearance bond. If you post bond, you'll be released. If you are released, do not possess or consume any drugs without a valid prescription. Do not possess or consume any alcohol. Do not drive a motor vehicle without a valid driver's license. Other release conditions will be reduced to writing in the written orders you're about to receive, sir. Any questions?
Yeah, the officer told me that I was only going to be charged with driving with an expired tag, none of this other stuff. I had no idea I was getting charged with any of this.
Understood, sir. It sounds like you may have some questions or take some issue with the underlying allegations here. So that's a question best suited for counsel. So I recommend that you talk to counsel about the underlying allegations here. Anything further? No. All right. Thank you very much, sir. You may step to your left. Numbers 15 and 16 on the calendar, Mariah Espinoza to the podium. Numbers 19, 20, and 21 on the calendar, Summer Ortiz to the chair, please.
Go.
Good evening, Ms. Espinoza. Please tell me your name and date of birth.
Mariah Espinoza, 4/11/1999.
Thank you very much. We're here today on 2 cases. Both of these are probation violation warrants out of the Maricopa County Superior Court. And the Adult Probation Department has filed petitions to revoke your probation, alleging that you have violated terms 3, 4, and 5 of probation. I am appointing the Public Defender's Office to represent you and setting a court date for combined probation revocation arraignment hearing and disposition hearing for May the 18th of 2026 at 8:30 in the morning at the Downtown Superior Court complex. I'm setting your bail in both cases in the amount of $250. That is a secured appearance bond for a grand total of $500 secured appearance. If you post bond, ma'am, you'll be released. If you are released, do not have any victim contact, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Contact your probation officer within 72 hours of your release if you are released. Other release conditions will be reduced to writing, written orders you're about to receive, ma'am. Do you have any questions?
No.
Thank you very much. Please step to your left.
Thank you.
Numbers 19, 20, and 21 on the calendar, Summer Ortiz to the podium, please. Number 2 on the calendar, Vantina Allison to the chair, please.
Hello, sir.
Hello, Ms. Ortiz. Please tell me your name and date of birth.
Summer Breeze Ortiz, 10/24/1996.
Thank you very much. We're here today on 3 cases. All 3 of these are, scratch that, one of these is a probation violation warrant. The other 2 are bench warrants that arise out of probation violation court. As to the probation violation warrant itself, the Adult Probation Department alleges that you have violated terms 3, 4, 5, and 7 of probation in a petition to revoke your probation. As to all three cases, Ms. Ortiz, I'm going to appoint the Public Defender's Office to represent you and set a court date for a combined probation revocation arraignment and disposition hearing on May the 18th of 2026. That's at 8:30 in the morning at the Downtown Superior Court Complex. As to release conditions for the bench warrant matters, I'm just going to affirm the bond amounts already set from the bench warrants. So that's $250, scratch that, $250 and $150. On the discrete probation violation matter, I'm setting bail at $200. So if you post bail, you'll be released. If you are released, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Contact your probation officer within 72 hours of your release. Other release conditions will be reduced to writing in the written orders you're about to receive. Do you have any questions for me?
No, thank you, sir.
Thank you very much. You may sit to your left. Number 2 on the calendar, Vanita Allison, to the podium, please. Number 27 on the calendar, Jose Mejia, to the chair, please. And good evening, Ms. Allison. Please tell me your name and date of birth.
Valentina Allison, 21093, sorry.
Thank you. We are here today on an arrest warrant out of the Maricopa County Superior Court. There's one charge, and this is charged out of a direct complaint. There's one charge of unlawful flight from a law enforcement vehicle, a Class 5 felony, alleged on or about February the 25th of 2026.
Okay.
I am appointing the Public Defender's Office to represent you, setting 2 court dates, the first on May the 18th of 2026 at 8:30 in the morning, the second on May the 20th of 2026 at 8:30 in the morning. Both of those are going to be at the Downtown Superior Court Complex. Okay. One is a status conference, one is a preliminary hearing.
Okay.
Ma'am, under the Arizona Constitution, you're eligible for bail. So I'm setting your bail at $500. That is a secured appearance bond. If you post bond, you'll be released. If you are released, do not possess weapons, do not possess or consume drugs without a valid prescription, do not possess or consume any alcohol. Other release conditions will be reduced to writing in the written orders you're about to receive. Do you have any questions?
No.
Thank you very much. Please step to your left. Number 27 on the calendar, Jose Mejia, to the podium, please. Number 26 on the calendar, Jerome Lashley, to the chair, please. And good evening, Mr. Mejia. Please tell me your name and date of birth.
Jose Amica Mejia Jr., 22898.
All right, Mejia. All right, thank you. Sir, we're here today on a new case out of the Encanto Justice Court. There's a new charge of driving with a suspended license, a Class 1 misdemeanor. I did find probable cause, and I am ordering that counsel be appointed to represent you at the next hearing, which is an arraignment at the Encanto Justice Court, which is on May the 14th of 2026. That's at 8:30 in the morning. Sir, I'm setting your bail at $500. That is a secured appearance bond. If you post bond, you'll be released. If you are released, do not possess weapons, do not possess or consume any drugs without a valid prescription, do not possess or consume any alcohol, do not drive a motor vehicle without a valid driver's license.
Good morning.
Conditions will be
Oh, there
in
you
writing
go. How you doing?
in the written order
Good,
you're
how
about
are
to
you?
receive.
Not bad. I was like, it should be on.
No.
Yeah, I know. I
Thank
had
you very
said
much.
good morning,
Please
but
step to your
I
left.
just missed you. You had walked out. The phone had rung. I just went out. Okay.
Number 26 on the calendar.
Officer, can I
Jerome
ask
Lashley
on
to
the
podium,
monitor,
please.
on the television, can you
Number
see the board on the
18,
left-hand
Isaiah
side?
Lamel, to the chair, please.
All I'm seeing is the state trusting board of
Okay.
court.
And
So if
good
I
evening,
can just have you
Mr.
push
Lashley.
2 buttons
Please
on
tell
the
me your name and date
tablet,
of
I'll
birth.
walk you through. On the
Lashley,
left-hand side, it'll say
Thank
you're
you.
in
We're here
attendee
today
view,
on
so
a
if you can just
warrant
push the
out
button
of
that says
the
switch to
Highland
presenter
Justice
view.
Court.
Gotcha.
This appears to be on a failure
And
to
then do you
appear
see like a
from
little text chat on
March
the
the
right-hand side of the
30th
television?
2026.
Is
Is it
I'm
on the
going to order that,
television?
and I'll get to your question in just a minute, sir, okay?
Oh,
I'm
yeah,
going
the chat,
to
yep,
order
the
that
chat.
counsel be
Okay, so
appointed
there's
to
a little
represent
chat
you at the
bubble
next
on the
hearing
tablet with a
and
blue
set a
line
court date
underneath
for
it,
you
and if you press
on
that
May the
once, it'll just
14th of
minimize the chat from the
2026.
TV.
That's at 8:30 in the morning at the Highland Justice
Perfect.
Court.
Thank you.
What was your question, sir?
Well, I was gonna say, I was in jail here last time. That court date was original on the
Check the
12th
one going
of
first.
March.
No, you can send
And I'm putting
as they come.
a request to let them know I'm already in jail. It hasn't changed So I don't know when, where they changed it, or give me a new court date, let me know. I've been stopped plenty of times, so I've been out of jail.
Yep.
In March. There's been no warrant, there's been no court, they told me here I had no court.
Chad Harris.
All right, sir. I'll take a look at this. I'm gonna have you sit back down so I can take another look at this. Officer, do we have, Mr. Lashley's booking date? Generally, just not on this warrant.
5/11, Your Honor, from 26.
Okay. All right, I'll take another look, sir. So give me a little bit of time. I'll come back to your case.
Good
okay?
morning. My name is
All right,
Pro
you may,
Officer
you
Dunkley,
may be
and
seated,
today
sir.
is
Thank you.
Monday, May 11th, 2026, and this hearing is of the Connecticut Board of Pardons and Paroles. The following board
Number
members are
18
present
on the
this morning,
calendar,
and by stating their
Isaiah
names on the
Lamel
record,
to the
certified they
podium,
have
please.
reviewed all statutory
Number
required
13 on the
documents
calendar,
and available
Audrey
for
Sheen
information
to the
in
chair, please.
preparation of this hearing.
And
Morning,
good
Mike
evening,
Paul.
Mr.
Robert
Lamel.
Sazowski.
Please tell me your name and date of birth.
Also
Girls,
present
that's
this
for,
morning is Dr. Walker. Please
and
state
your
your
name,
name
sir.
and inmate number for the record.
Thank you, sir.
Chad Harris.
We're here today on a
number
probation violation
427
warrant from the Maricopa County Superior
This
Court.
hearing is
The
being
adult
conducted
probation
in
department
consideration
alleges
of
in
the
a
parole
petition to
application
revoke
for
your
Chad
probation that
Harris,
you have
inmate number
violated terms 3, 4, and 5
427-177.
of
He
probation.
is serving a total
I am
effective
appointed the
sentence
public
of 10
defender's
years,
office to
executed
represent you,
suspended
in setting a
after 4
court date
years
for a
and 10
combined
years of
probation,
probation.
revocation, arraignment,
For
and
sexual
disposition
assault
hearing
setting. As of
on
today's
May
record
the 18th
reflects
of
the parole
2026 at
eligibility
8:30
date
in the
of
morning
May
at the
5th,
downtown Superior
2025.
Court complex.
There is no victim input in this case.
Sir,
There
I'm
is an
going to
offender
set your bail at
accountability plan for the
$200.
offender.
That
It
is
has
a
been
secured
completed,
appearance
so the
bond. If you
offender
post
has
bond, sir,
completed
you'll
the
be
bond.
released. If you are
He is the
released, do not
short
possess weapons, do
and
not possess or
voices.
consume drugs
Citizens
without a valid
class.
prescription, do not possess or
Utilizing
consume
the
any
statewide
alcohol.
collaborative offender
Contact
risk
your probation
evaluation
officer
system, the
within
embedded
72
toolbox
hours of
will
your
fall
release
within the
if
low
you are
range of risk
released.
for recidivism.
Other release conditions will be in
Utilizing
writing
the static
in the written
99R,
notice
the
you're about
offender's
to
overall
receive,
score
sir.
for
Do
the
you have any
sexual offense
questions?
recidivism falls
All right,
within
thank
the
you,
low
sir.
range.
You may step to your left.
Mr. Harris, this is
Number
your opportunity
13
to
on the
express the
calendar,
board why
Audrey
you
Sheen,
should be
to
granted
the
parole.
podium,
You may
please.
begin.
Number 1 on the calendar, Jolene Sproul.
I apologize to the victim and to my family and friends
Good evening, Ms.
for the
Sheen. Please tell me your
actions that
name
I
and date
did.
of birth.
March 30th,
I know it caused a lot of hurt
2000, Audrey
and pain,
Thank you. We're
anger,
here today on a new
embarrassment,
case out of
disappointment.
the North Valley Justice Court.
I'm hoping
There are 3
with
charges. The
time,
first
everyone
is disorderly
continue to
conduct,
heal
a
with
class
this.
1 misdemeanor. There are 2 counts of false reporting to law enforcement, also a class 1 misdemeanor.
Is that it, Mr. Harris?
I did find a probable
sir.
cause.
Okay, so you know.
I'm ordering that counsel be appointed to
you know what
represent you
happens
at
here.
the next hearing at
So
the
we're
North
here.
Valley Justice Court, May the 14th of
And so
2026.
what we're gonna do
At
is,
8:30 in the
take
morning at
turns
the
asking
downtown, correct
questions.
that, at the North Valley Justice Court, as I said.
And,
Under the
going
Arizona
to,
Constitution, you
talk
are
about your
eligible for
case and
bail.
give you a
I'm setting your
decision,
bail at
okay?
$50.
Yes, sir.
That is a secured
And we're gonna
appearance
start,
bond. And if you post
questions
bond,
this
you'll be
morning with
released.
board members exhausted.
If you are released, do not possess any weapons, do not possess or consume any
Chair, I
drugs
have
without a valid
some
prescription. Do not
questions,
possess
final
or
question
consume
that
any
refers
alcohol.
to some
Other release conditions will be in writing
protected item
in the written notice you're
information.
about
I
to
would
receive.
request that
Do
we
you have
have
any
an executive
questions?
session for these questions.
I'd move that
If
we go
I-
into
can I, like,
executive
bail
session,
myself out
to
if
talk
I have,
about confidential
like, the cash
information. Is there a
in my
second?
possession,
Those in
or?
favor
If you
signify
wish
by
to
saying
post
aye.
bail, please
Aye.
talk to
Those
your
opposed,
detention
no.
officer for
The ayes
details on
have
how
it,
to do
and
that.
we will go
Okay.
into executive
Thank you very
session.
much.
Thank you.
Thank you.
Mr. Harris, can you get the CO, please?
Yes,
Number 1 on the calendar, Julianne Sproul to the podium, please. Number 3 on the calendar, Gabriel Trevino to the chair, please. And good evening, Ms. Sproul. Please tell me your name and date of birth.
My date of birth.
Yes, your name
We're
and your
going
date of birth.
to,
Jolene Sproul, 52986.
Thank you very much. We're here today on a bench warrant from the Maricopa County Superior Court. The date of the warrant
The board is gonna, speak to Mr.
is
Harris
from
off the
October the
record, so if I could just
22nd
get your
of
help. I'm gonna
2025.
disconnect this call and send you a
Okay,
brand new
here.
call in just a moment.
I'm affirming the appointment of the
So when that
existing
new call
counsel
pops up
and
on the
setting
screen, if you
a
can
status
press
conference
accept.
for you
All right.
on May the 18th
So just
of
give me one moment.
2026 at 8:30 in the morning at the downtown Superior Court complex. Under the Arizona Constitution, you're eligible for bail. I'm setting your bail in the amount of $50. That is a secured appearance bond. If you post bond, ma'am, you'll be released. If you are released, do not possess or consume drugs without a valid prescription. Do not possess or consume any alcohol. Other release conditions will be in writing in the written orders you're about to receive. Do you have any questions?
No, I have the money on my books. Am I able to use that to bail out?
Well, as I said before, if you want further details on how to post bond, please talk to your detention officer for details on how to do so. All right?
All right,
Okay,
thank
thank
you,
you
sir.
very much.
Thank you.
Number 3 on the calendar, Gabriel Trevino to the podium, please. Number 23 on the calendar, Luis Calderon to the chair, please. And good evening, Mr. Trevino. Please tell me your name and date of birth.
Gabriel Torino, 2585.
Thank you very much. We're here today on a new case from the Maricopa County Superior Court. There's one charge of possession of dangerous drugs, class 4 felony, for which I did find probable cause. I'm appointing the Public Defender's Office to represent you, sir, and I'm setting a status conference for May the 26th of 2026 and May the 29th of 2026. Both of those are at 8:30 in the morning at the downtown Superior Court complex. Do you promise to appear?
Yeah, I'll appear, yes.
Based on your promise to appear, it's ordered releasing you on your own recognizance. If you fail to appear for a court date, a warrant will issue for your arrest. Additionally, as you are released, do not possess or consume drugs without a valid prescription. Do not possess or consume any alcohol. The release conditions will be reduced to writing in the written notice you're about to receive, sir. Do you have any questions?
No.
All right, thank you, sir. You may step to your left. Number 23 on the calendar, Luis Calderon. And then we'll recall Mr. Lashley after Mr. Calderon. So Mr. Lashley to the chair, please. Is he still here? Oh, there he is. Okay, wonderful. Excellent. All right, Mr. Calderon, please tell me your name and date of birth.
Luis Martinez Calderon, September 5th, 1981.
Thank you, sir.
You're welcome.
We're here today on a family court warrant from Maricopa County Superior Court. This is a non-criminal matter. It's a civil matter. So given that I am not appointing counsel, given the nature of the civil contempt, so I am going to set a court date for you, sir, on May the 14th of 2026. That's at 10 o'clock in the morning at the downtown Superior Court complex for the return on warrant hearing, okay? The purge amount on the warrant is $500. If you post the purge amount, the $500 will be released, sir. Do you have any questions?
No.
All right, thank you very much. You may step to your left, sir. All right, Mr. Lashley, you may approach the podium again. And yeah, just right there, sir. Thank you. So, sir, let me just take a quick look. Sir, I took another look. Based on the records that I have available to me, I'm seeing the arrest date as May the 10th of 2026. So I'm not seeing a historical booking information to corroborate what you're telling me.
What was the original charge date? You know what I'm saying?
Well, the warrant date, sir, is from March the 30th of 2026. So, given that, sir, I'm going to set your bail at $500. That is a secured appearance bond. Also ordering that counsel be appointed to represent you at the next hearing, which is, again, May the 14th of 2026 at 8:30 in the morning at the Highland Justice Court. Other release conditions will be in writing, sir, that you'll receive. Any further questions, sir? All right, thank you, sir. You may step to your left. Let's go ahead and clear the gallery for our last matter, please. Okay, that's fine. I'll do some house calls while we're waiting. This is number 12 on the calendar. Jonathan Shirley, date of birth 9/3/1992. Mr. Shirley's not here present in the courtroom. The note from the sheriff's office was unable to function, unsafe behavior. We'll proceed in absentia for the time being with the house call. This is a new case from the Maricopa County Superior Court. There's one count of resisting arrest, one count of disorderly conduct, resisting arrest being a Class 6 felony, disorderly conduct being a Class 1 misdemeanor. I did find probable cause. I'm appointing the Public Defender's Office, setting 2 court dates for May the 18th and 20th of 2026 at 8:30 in the morning at the Downtown Superior Court Complex, setting bail in the amount of $2,500 with pretrial service supervision to the Pretrial Services Agency. Other release conditions will be in writing that will be provided to Mr. Shirley during the cell side initial appearance that will be conducted immediately after the conclusion of the 8 o'clock calendar. If there are any changes to the release orders, they'll be reflected in the written orders and not on the audio-visual feed here. That will adjourn number 12 on the calendar, Jonathan Shirley. Moving now to number 11 on the calendar, Xavier Theroux, date of birth 3/26/2006. Mr. Theroux is not here in the courtroom. The note from the sheriff's office is that Mr. Theroux is in isolation due to bizarre behavior. So we'll proceed in absentia for the time being with the initial appearance. This is a new case from the Maricopa County Superior Court. There are 3 charges of aggravated assault with a deadly weapon or dangerous instrument, a Class 3 felony. I did determine probable cause. I'm appointing the Public Defender's Office and setting 2 court dates for May the 18th and 20th of 2026, both at 8:30 in the morning at the Downtown Superior Court Complex. I'm setting bail in the amount of $50,000. That is a secured appearance bond with pretrial supervision to the Pretrial Services Agency and mandatory electronic monitoring to be installed before release. Other release conditions will be in writing in the written orders that will be provided to Mr. Theroux during the cell side initial appearance that will be conducted immediately after the conclusion of the 8 o'clock initial appearance calendar. That will adjourn. Oh, and if there are any changes, they'll be reflected on the written orders, not on the audio-visual feed here. That will adjourn number 11 on the calendar, Xavier Theroux. Moving now to number 4 on the calendar, Samir Kosick, date of birth 3/11/1982. Mr. Kosick was being held in psych holding over at the Lower Buckeye Jail, so he was unable to be transported for the initial appearance here live in the courtroom. So at the beginning of the 8 o'clock calendar, the initial appearance was conducted remotely with the defendant via jail tablet due to the housing restrictions from the sheriff's office. And so I will read into the record the outcome of the initial appearance to include the release conditions. This is a Justice Court warrant from the Santan Justice Court. This is arising out of a bench warrant. I'm ordering that counsel be appointed to represent Mr. Kosick for the limited purpose of bond at the next hearing, which is May the 14th of 2026 at 8:30 a.m. at the Santan Justice Court, setting bail at $680, secured appearance, with other release conditions that will be reduced to writing in the written orders that Mr. Kosick will receive from the sheriff's office. That will adjourn number 4, Samir Kosick. We all set on our last matter? Okay, very well. We'll now call numbers 5, 24, and 25 on the calendar, Robert Ator, to the podium, please. And good evening, Mr. Ator. Please tell me your name and date of birth.
Robert Ator, 9/25/76.
Thank you. Sir, we're here today on 3 cases. The first is a grand jury warrant from the Maricopa County Superior Court. The other 2 matters are probation violation warrants from the Maricopa County Superior Court. The probation violation matters are alleged as term 1 violations. As we know, term 1 of probation is do not commit new criminal offenses while out on probation. Here we have a new submission in the form of the grand jury warrant. So on the grand jury warrant, that means that a grand jury has found probable cause to hand down an indictment accusing you of 1 charge of failure to register as a sex offender, a class 4 felony, 1 charge of failure to confirm identification as a sex offender, a class 6 felony, count 1 alleged on or about December the 5th of 2024, count 2 alleged on or about July the 9th of 2025. On all 3 of your cases, sir, I am appointing the Public Defender's Office to represent you. As to the new case, sir, I'm setting your court date on May the 19th of 2026. That's at 8:30 in the morning at the Downtown Superior Court complex. As to the probation violation matter, sir, setting your court date for a combined probation revocation arraignment and disposition hearing on May the 18th of 2026. That's also at 8:30 in the morning at the Downtown Superior Court complex. On your new case, sir, under the Arizona Constitution, you're eligible for bail. Therefore, affirming the amount already set in the grand jury warrant, sir, that's $2,000. That's a cash-only appearance bond with pretrial supervision and mandatory electronic monitoring to be installed before release. Other release conditions will be in writing on that case that you'll receive. However, as to the probation violation matters, pursuant to Arizona Rule of Criminal Procedure 7.2C, I'm ordering that you be held without bail at this time. Do you have any questions, sir?
Yeah, what did you say the charges were?
Failure to register as a sex offender, the class 4 version, which is the failure to register, and the failure to confirm or update ID, the class 6 version. So the count 1 is alleged December the 5th, 2024. Count 2 was alleged July the 9th of 2025, sir. Anything further?
No.
All right, thank you very much, sir. You may step to your left. That will bring us to the end of the... Sorry?
I'm taking out real quick, and I'll come back for...
Excellent. All right, thank you. That will bring us to the end of the 8:00 p.m. initial appearance calendar for May the 11th of 2026. We will stand in recess.
We go to that. And then we're gonna get rid of this. I think we just make sure it should be set. Yeah, so she's back in, so she'll be back. You know. Your meeting coming up. We're on the meeting, so this one there.
Yep. Thank you all.
Thank you. Thank you.
Kristen? Thank you.
All right, Mr. Harris. All right, Mr. Harris, so the executive session is ended, and now we're back to the regular hearing. Now return to board members' offices for questions.
So, Mr. Harris, can you just talk about any insight you have gained into why you committed this assault on the victim?
I don't know why I committed it. I only know how I could prevent it from happening again through treatment programs, through more mental health for me.
Okay. Some of the documents I reviewed, it says that you subscribed to the victim's OnlyFans page and that you sent us a request to offer more money for nude photos. This was after, it sounds like, according to my documents. You recall that?
I do not.
You ever gone on to OnlyFans?
No. Never.
Did you know that the victim was on OnlyFans?
I did not. No.
You took the Voices program, right?
Oh, it's right here. Okay.
All right, this is the 11 p.m. initial appearance calendar. It is May 11th, 2026. Before we begin, I have two advisements to read. First, if you're the victim of a crime with a case pending before this court, you are advised that you have certain rights under law. Among others, these include the right to be treated with fairness, respect, and dignity, the right to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defense, to be heard before the court makes a decision about release, about the negotiation of a plea, about scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not received a written statement of all of these rights, please contact the Victim Services Division of the Prosecutor's Office. Additionally, the court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month remain in effect for all the matters on this calendar. All right, ladies and gentlemen, this is the initial appearance calendar. So we will be doing all of your initial appearances. I will call each one of you individually into the courtroom, and we'll try to make it as efficient as possible. So please, first off, listen down for your name to be called. When it is called, please kindly make your way to the podium in the center of the courtroom. I will also let everyone know who is second in line, and I will ask that person to please take a seat in the chair directly to the left of the doorway. And hopefully this will keep things moving as quickly as possible. Once you are in the courtroom, I will go over several things with you. I will first let you know what type of matter you're being seen on. I will let you know whether the court is appointing an attorney to represent you. I will let you know when your next court dates are and whether you are eligible for release. If you are eligible for release, I will go over your release conditions with you. Please be aware that when we go over release conditions, I will likely go over the most important conditions with you. However, you must make sure to review your paperwork and understand and comply with all of the release terms on the paperwork. That paperwork will have a full and complete list of all of the terms. All right, with that, let's start with Jonathan Lascano, and then second, we will have Mackie Kendrick. Sir, may I have your name and date of birth, please?
Jonathan Lascano, 10/22/1989.
Okay. Sir, you're here on two matters. They're both probation violation matters. The first one is in your criminal case CR 2020-14214. In that case, you are on probation for possession of a weapon by a prohibited possessor, okay? And the second probation violation matter is in CR 2021-000-190. In that case, you're on probation for possession of narcotic drugs. In both of these cases, you are alleged to have violated terms 6, 7, and 21 of your probation. The court is appointing you an attorney to represent you in both matters. And in both matters, you have a probation revocation arraignment and possible disposition on May 18th at 8:30 a.m. All right, that date and time are going to be in your paperwork. So you are not eligible under law for release terms, okay? So the court has found that you, in all reasonable probability, will likely serve a sentence of imprisonment by virtue of these two probation violation matters. Therefore, pursuant to Arizona criminal rules, you are not eligible for release, so you don't have a bond. Okay, this is certainly something that you can discuss with your attorney. Your next hearing is in exactly a week, and I'm sure that you'll be meeting with your attorney then. All right. All of this will be written down in your paperwork, sir. That concludes your hearing. So you may get your paperwork to your left. Okay. Thank you. All right, may I have Mackie Kendrick, and then we will have Calvin Ben. All right. May I have your name and date of birth?
Makai Kendrick, 10/26/2002.
Okay, I'm sorry that I mispronounced your name, Makai. All right, and do we have the alleged victim on the line with us?
Yeah, I'm here.
Okay, and ma'am, before I start the initial appearance, is there a statement that you would like to make to the court for the court's consideration?
Yes.
Okay, why don't you go ahead with that? We'll start with that first. So please go ahead and tell me what you'd like to say.
Okay. So it's kind of hard to talk about, so sorry if I get like shaky. But I was in a relationship with him, and he beat me for about 8 months, consistently in front of my kids for hours. He went to jail for that, for torturing me and my children. And I have a lifetime injunction against him. And as soon as he got out of jail, he was contacting me while he was in jail. He got out and was stalking my house, contacting me on social media through other people. He was just in custody recently and was almost bailed out today. And he contacted me through a three-way call just a couple of days ago. And so I don't believe that he deserves I think that he needs to get no bond. And if he does, he needs to be on the ankle monitor because he will go on the run like he has before. As soon as he got out of jail, the last time he went on the run to Albuquerque, Mexico, and he has a gun charge now. He's just living it up and hurting people over and over again. He beat another woman for 4 years consistently, and the police was called on him as soon as he got out for going to her house with a gun as well. He's not a good person. He's not changing, and I just don't think he deserves any leniency. That's all I wanted to say.
Thank you so much for that, ma'am. All right. All right, so Mr. Kendrick, you are here on one matter. This is an allegation of a violation of your probation. This is in criminal case CR 2024-126540.
It's right.
I can't see exactly. Wait, just stay right there. It's okay. Let me go through the rest of this, and I'll see if you have any more questions. Okay. So, in this case, you are on probation for aggravated assault, and you are alleged to have violated term 15. Okay. So the court is appointing you an attorney to represent you, and you have a probation revocation and possible disposition hearing on May 18th at 8:30 a.m. All right. So before I get into release conditions, the court did hear from the victim. The court will give you an opportunity to say something regarding your release. However, I want to caution you that you have the right to remain silent. So I don't want to hear anything from you about these allegations. But if there's anything else that you would like me to know, you may make a statement.
Okay, so I came to court and I got bonded out pretty much for today for the same exact thing. And I tried to contact my probation officer to see what's going on. I didn't know I sat in jail for 38 days, and Project Bail Bonds came and bonded me out. And this is literally the same exact thing. I could not possibly did anything while in incarceration. And as soon as I got over there, they told me that I got page 2. I don't know what's going on, but I paid my bond. I have not been in contact. It's a he say, she say right now with no, but that's really all I have to say. I'm just thinking so much confusion right now.
Okay, so that is right. You have been page 2, and specifically the allegation is that you, just give me 1 second. That while you were in the jail, that you contacted the victim, I believe it was on either May 4th or May 5th, in violation of a court order. I'm not sure what paperwork it is that you are showing me. You can address that with your attorney, okay? You are not eligible for release in this matter, all right? So the court is making a finding that you will, in all reasonable probability, receive a sentence of imprisonment in this matter. The court notes that you are on probation in this criminal case number for aggravated assault, that, you were on warrant status for a year, that you have allegedly made repeated contact attempts with the victim, one of those contacts resulting in this page 2 probation violation issue. So for today, you are not eligible for release. You may discuss that with your attorney, of course, and your next hearings again are on May 18th at 8:30 a.m. Okay? Thank you. You may step to your left, get your paperwork. That concludes this matter. So if the victim on the line wants to disconnect, that is fine. Thank you, ma'am, for appearing. All right. We have Calvin Ben and then Maurice Hawkins. Hello, may I have your name and date of birth?
Calvin Ben, 4/12/86.
Okay, thank you. You're here on one matter. That matter involves allegations of new offenses, specifically 2 counts of aggravated assault, both as Class 3 felonies, and 1 count of resisting arrest as a Class 6 felony. The court has found probable cause as to all 3 of those allegations. The court's appointing you an attorney, and you have a status conference on May 18th and a preliminary hearing on May 20th. Both of those are at 8:30 in the morning. You are eligible for release. The court is imposing the following terms. You have a secured appearance bond in the amount of $75,000. In addition to that, you're ordered not to go back to the scene of the alleged crime. You're not to have any contact with any alleged victims or arresting officers. No weapons, no drugs, no alcohol, no driving without a valid driver's license. You're ordered not to leave the state, and you must notify the court of any new address. Okay, all of that is written down for you, and you may get that paperwork to your left, right? Oh, you know what? I'm so sorry. Mr. Ben, just one more moment. I do want to put on the record in your matter, I do see that you're arrested on May 10th, and that was at 3:29 p.m. You have 24 hours typically under Arizona law to be seen in initial appearance court. The court is making a finding of extraordinary circumstances, specifically that when you were arrested, you were exhibiting signs of some type of delirium, and you were taken straight to the hospital at Banner Desert. You were then released today's date, and within 6 hours of your release from Banner Desert, you were brought into the facility here, into the jail here, okay? So I am making extraordinary circumstances findings that you had to be seen first to be medically cleared. That took some time, and that's why you weren't seen before me within 24 hours of your arrest, okay? Thank you so much. I appreciate it. All right, Maurice Hawkins and then Jack Pierce. All right, may I have your name and date of birth?
Maurice Hawkins, 10/28/05.
Thank you so much. All right, so you're here on one matter. It's an allegation of a new offense, specifically 1 count of armed robbery as a Class 2 felony. The court has found probable cause as to that allegation and has appointed you an attorney. You have a status conference on May 18th at 8:30 a.m. and a preliminary hearing on May 20th, also at 8:30 a.m. You're eligible for release. The court is imposing the following conditions. You have a secured appearance bond in the amount of $75,000. If you post that bond, you will be released to the supervision of pretrial services. Before you would be released from the jail, they would put an ankle monitor on you. And you'd have a curfew that you'd have to abide by. The times of that curfew would be determined by the pretrial services officer. Additional terms of your release are you're not to return to the scene of the alleged crime. You are not to initiate contact with any of the alleged victims. Just give me 1 minute. Can we reprint this one, please? Oh, you know what? Never mind, I don't think we have to reprint it. Never mind. Okay, so no contact with any victims or any arresting officers, no contact with any co-defendants, okay? You're ordered not to possess any weapons, no drugs, no driving without a valid license. You're not to leave the state of Arizona.
Yes, of course.
Okay. Additionally, no possession of any simulated weapons. Okay?
Of course.
Do you understand all of those conditions?
Yes, ma'am.
Okay. All right. That concludes your hearing. You can get your paperwork. Thank you.
Will I be released or not?
You will be released if you can post the secured bond in the amount of $75,000.
Dang.
Okay. Hold on. Release order. Okay. Did I get it right? Okay. All right, Jack Pierce and then Brian Acosta. All right, may I have your name and date of birth?
I can't hear very well.
Okay. Name and date of birth?
4172,
Okay, and can I have your name?
Jack Wayne Pierce.
Thank you so much. All right, so you are here on 2 matters. The first matter involves allegations of new offenses. All right, can you hear me okay?
No.
Okay. Is there anything that, are you hearing impaired?
Huh?
Are you hearing impaired?
Yeah, I'm losing my hearing.
Okay. Does it help if I speak up?
I haven't really figured out how to do it.
Okay. Thank you. Let's give this a try. All right, is that better?
That's perfect.
Okay. All right, so the first matter involves allegations of new offenses. I'm going to go over them with you. There's one count of unlawful flight from law enforcement as a Class 5 felony. One count of reckless driving is a Class 2 misdemeanor. One count of assault, a Class 1 misdemeanor. 2 counts of failure to obey a court order. Both of those are Class 1 misdemeanors. 2 counts of criminal damage is Class 1 misdemeanors. And 1 count of criminal trespass as a Class 1 misdemeanor. The court has found probable cause as to all of those allegations except for the 2 counts of criminal damage. The court, thank you so much. Okay. So the court did not find probable cause as to those criminal damage allegations. I see that you did not, I don't believe you participated in the financial affidavit. Did you fill one of those out? Okay, so the court cannot today make a determination, of indigency. So I don't know about your financial status, and therefore I can't appoint you an attorney.
I'm homeless.
Okay, so would you like to answer a few questions about your finance? Okay.
No.
All right, so do you have any income?
Do what?
I'm sorry, Deputy, is there something we can do?
You still here?
No.
Well, I'm gonna try to turn all the way down. So now.
All right. Are you employed?
No, I'm not.
Okay. So I'm assuming that you don't have a monthly income?
No, ma'am.
All right. Do you have any assets or any money in an account that you could use to pay for an attorney?
No, ma'am.
Okay. All right. So based on that, I am going to appoint an attorney to represent you. So we'll have to reprint this, please. All right, so in this matter, you have a status conference on May 18th and a preliminary hearing on May 20th at 8:30 a.m. Both are at 8:30. The dates and times will be on your paperwork. In this matter, you are eligible for release, and the court is imposing the following terms. You have a secured appearance bond in the amount of $50,000. If you post that bond, you will be released to pre-trial services, and before you leave the jail, they will put an ankle monitor on you. At that point, you will have a curfew that you'll have to abide by, and the hours of that curfew will be determined by the people at pre-trial services. You have other really important terms of your release. You are not to return to the scene of the alleged crime. You're not to initiate contact with any of the alleged victims. No contact with any arresting officers, no weapons, no drugs. You are ordered not to leave the state and to contact your probation officer within 72 hours. In your second matter, we're going to have to reprint this as well. All right, in your second matter, you're here for a probation violation matter, and that's in your criminal case CR 2019-119029. In that case, you're on probation for 1 count of burglary as a Class 4 felony. You are alleged to have violated Term 1 of that probation. Term 1 is no new offenses. The court is appointing an attorney to represent you in this second matter. You have a probation revocation arraignment and possible disposition on May 18th at 8:30 a.m. You're eligible for release in this matter. You have a secured appearance bond in this matter in the amount of $500. Additional release terms in this case will be listed in your paperwork. All right, so that concludes your hearing. You may get your paperwork to the left. And then deputy, just give me one moment. Okay, so we will have Brian Acosta and then Cynthia Acuna. Hello, may I have your name and date of birth?
My name is Brian Acosta, 12/31/2003.
Thank you so much. Mr. Acosta, you're being seen on two matters. The first matter involves an allegation of a new offense, specifically one count of unlawful flight from police. That's a Class 5 felony. The court has found that probable cause exists as to this allegation. The court reviewed your financial affidavit, and it does appear that you have some money left over at the end of the month after you pay for all of your bills. Do you have enough money left over at the end of the month to hire a private attorney?
Not sure.
Okay. All right. All right, so I have that you make $3,466 a month. Is that right?
Yeah.
Okay. And is that your take-home amount?
No, I don't take that at home.
Okay. How much approximately is your take-home amount?
$1,200, $1,500.
Okay. And then I have your total expenses as $2,140?
Yeah, somewhere around there.
Okay.
She didn't add everything. I have other things under my credit card that I buy too.
Okay. So, so then from what I'm understanding today is that you have more in expenses and bills than you actually take home every month. Is that right?
Yeah.
Okay. All right. So let's edit this one. I'm sorry. All right. So I am going to find, based on your statements, that you are indigent, meaning I am going to appoint an attorney from the Public Defender's Office to represent you. All right, you have a status conference in this new matter on May 18th at 8:30 a.m. and you have a preliminary hearing on May 20th at 8:30 a.m. All right, those are going to be listed on your paperwork. You are eligible for release, and the court is imposing the following terms. You have a secured appearance bond in the amount of $5,000, right? If you post that bond, you will be released to pretrial services. You'll have to comply with their rules.
Okay.
Do you understand?
Yeah.
Okay. Other terms of your release are you're not to have any drugs, no alcohol, no driving without a license, and you're not to leave the state of Arizona. Additionally, you've got to contact your PO within 72 hours.
Okay.
Right?
I got a question.
Sure.
I never done that post bond thing. How does that matter work?
Well, it's not a cash bond, it's a secured appearance bond, meaning you typically have to post about 20%, okay? So either you get that money somehow, or there's a list of bail bondsman companies in the back. You can try to reach out to one of those companies for assistance with that.
Okay.
So your second matter is an allegation of probation violation. That's in your criminal case CR 2025-114249. In that matter, you're on probation for endangerment. You're alleged to have violated term 1 of your probation in this case. Term 1 is no new offenses. So by virtue of your new case, they're alleging that you violated your probation, right? You have an attorney appointed in this matter as well, and you have a probation revocation arraignment and possible disposition on May 18th at 8:30 a.m. You're eligible for release in this case as well, and you have, in this case, a secured appearance bond in the amount of $250, all right? So you have bonds in both cases. You have additional terms of release that apply specifically to this second case, and all of the terms of release are going to be listed in your paperwork, so make sure that you go through them.
Okay.
Right? Okay, that concludes your hearing. Okay, so you may step to your left and get your paperwork.
Okay, thank you.
All right, Cynthia Acuna and then Joseph Mendez. Give me one moment. Okay. All right, the court is noting that there was a victim impact statement filed in conjunction with Ms. Acuna's matters. The court does want to note that that victim impact statement seems to pertain more to the circumstances surrounding Ms. Acuna's apprehension, and not specifically as to the 2 matters that she's here for. The court did read that statement, and given the circumstances of the statement, we'll give it the weight that the court can. All right, Ms. Acuna, would you please state your name and date of birth?
Cynthia Marie Valle Acuna, 11/7/87.
Thank you so much. All right, so you're here on 2 matters, okay? The first matter is in CR 2026-000032. All right, that is a matter in which an arrest warrant issued when the county attorney's office filed a direct complaint, basically just a new case, okay, charging you with 1 count of unlawful use of food stamps, Class 6 felony, 1 count of fraudulent schemes and artifices, a Class 4 felony, and 1 count of theft as a Class 3 felony, right? The court is appointing an attorney to represent you in this matter, and you have a preliminary hearing on May 18th at 10:30 a.m. You are eligible for release in this first matter. The court is imposing the following terms. You have a secured appearance bond in the amount of $5,000. I'm going to go over some additional terms with you, but please see your written paperwork for the full list. You're not to have any contact with any alleged victims. You're not to go to the scene of the alleged crime, no drugs. You're not to leave the state, and you must contact your probation officer within 72 hours, right? Your second matter is a probation violation allegation in CR 2023-113429. In this second case number, you're on probation for possession of drug paraphernalia. You're alleged to have violated terms 3 and 5 of your probation. The court is appointing an attorney to represent you in this matter. You have a probation revocation arraignment and possible disposition hearing. That's on May 18th at 8:30 a.m. You're eligible for release in this matter, and the court is imposing a $200 secured appearance bond. Right? You have other terms of release in the second matter, so please make sure that you review your paperwork and that you understand and comply by all of the terms of your release. All right? Thank you. That concludes your hearing. All right, and we're just going to take one quick minute. All right, Joseph Mendez, please, in the courtroom, and then Marquita Lewis will be next. Hello, may I have your name and date of birth?
I'm Joseph Mendez, 7/11/89.
Okay, thank you so much. All right, you're here on 2 matters.
Is there any way I could speak real quick?
Let me get through this stuff, and then if you have any questions or anything you want to say, then we'll get to that, okay?
Yes, ma'am.
All right, so the first matter is in case CR 2019-132198, right? That's an older case.
That's what I'm on probation for right now.
Okay, just give me 1 second, all right? So in this case, there was a failure to appear bench warrant that was issued, all right? And that was for, okay, just give me 1 second, okay? It's all right. That was for failing to appear at a status, hold on. I'm sorry, just give me 1 minute. Okay, I'm so sorry. So your 2019 case, all right, so you're on probation for theft of means of transportation and possession of a weapon by a prohibited person.
Yes.
Does that sound right? Okay,
Yes.
I got them switched first. So 2019, your older case, is the one we're talking about. This is an arrest warrant on some post-conviction matter, okay? And so the warrant issued, you have an attorney at the legal advocate's office. The court is going to appoint the legal advocate's office to represent you in this warrant issue. You have, just 1 second, you have a probation revocation arraignment hearing and possible disposition on May 18th at 8:30 a.m., and you are eligible for release. When the warrant issued, the judge issuing the warrant requested a $100 cash bond, okay? And the court is going to affirm that. Now, is there something that you want to say about
that case? I'm on probation. Like I said, I'm on probation for that right now. I just got done doing prison time for that case. I was on a year probation. I'm 4 months away from completing probation. I've never been successful in probation, nothing. I go to work every single day. I raise my 10 kids. My girlfriend's brother has NF. I believe that's what it's called, NF or something like that. He had seizures for 2 days straight, was in the hospital, was in a coma for 2 days. He's autistic as well. We're helping him right now, trying to get everything situated, get him put right and everything like that. That's the reason why I missed court. I'm not trying to run. I'm not trying to do that. I should have came into court and, explained myself a little better. I got afraid.
Okay.
They put a warrant out. I heard the warrant and I did something very stupid. I'm trying to be a father to my kids, turn my life around, and I messed up. I made a mistake. I'm asking the court, please, Your Honor, give me a second chance. Let me go out there. Let me prove to you guys, not only to you, but to myself, that I can do better. Like I said, this is the first time any time I've ever been in trouble. I've been successful. I go to work every single day. I raise my 10 kids. I'm trying to be on track here. I made a mistake, and all I'm asking is, please, Your Honor, give me a chance. Let me go out there. Let me get back to work and keep doing the right things that I'm doing, and make it in life. That's all I'm asking. I made a mistake. I made a big mistake, and
Okay.
I'm about to lose my family because I did something stupid.
Okay.
Going back to prison is not where I want to be at.
I understand. Thank you, and I appreciate that. Okay. So the court is, the court. Here's what you're saying. The court is affirming that $100 bond.
I have no cash right now. I'm helping my my girlfriend's brother's family as well as mine.
I do. I understand. The court has.
I understand
the court
that.
has to weigh all the factors. All right.
I understand that. Like I said, I don't have money for that. Like I barely make it on a little bit. I have. I make now.
You have this isn't your only matter.
Okay? No, I understand that.
We have a second matter that we still have to get to, okay? So, you have a hearing set on May 18th at 8:30 a.m., all right? That's in a week, okay? The court is appointing an attorney that can, help you with your release conditions. You have a series of other release conditions. All of those are going to be written in your paperwork. Right, so in your second case, that's CR 2026-113538.
Yes, I see what you're looking at, miss.
Just give me 1 second, okay? All right, so in this matter, failure to appear bench warrant for status conference, that's in the case involving 1 count of possession of dangerous drugs and 1 count of possession of drug paraphernalia. All right, so you have an attorney who's going to represent you in this matter, and you have different court dates in this case. You have a status conference on May 18th at 8:30 a.m. and a preliminary hearing on May 20th at 8:30 a.m. All right, so you are eligible for release. In this matter, the trial court judge did request a secured appearance bond in the amount of $1,000, and this court is affirming that for today's purposes. All right, the remainder of your release conditions are on your paperwork.
So they come with $1,100.
20%, yeah.
So what's 20% of the $150?
220.
220?
Mm-hmm. Yeah.
It was $1,000.
Well,
if there's 10% of
right. So it's
so it'd be $1,000 would be $100, and then all right, I see.
Okay. All right. All of that's in your paperwork. Okay. All right. Thank you. If that concludes your hearing. Thank you. Marquita Lewis and then Christopher Armendariz. Hi, may I have your name and date of birth?
My name is Marquetta Lewis. Date of birth is 06/19/1986.
Okay, I'm sorry for mispronouncing your name. All right, so you are here on one matter. That matter involves allegations of 3 new offenses. They are 1 count of assault, is a class 1 misdemeanor, 1 count of burglary is a class 4 felony, and 1 count of criminal damage is a class 1 misdemeanor. So the court has found probable cause as to all of the allegations except for the criminal damage allegation. So, that doesn't mean that you won't ultimately be charged with criminal damage, but based on the limited information that I have today, I'm not finding probable cause as to that one. All right?
As far as burglary, I'm trying to figure out where I get burglary from because I wasn't trying to steal anything. As you can see.
Just 1 minute, okay? So I want to remind you that you have the right to remain silent, and I really don't want you to make any statements about these allegations because they would be used against you. All right? So let me just get through the rest of the information that I need to, and then I'll ask if you have any questions.
Okay.
Right? Okay. So the court's appointing an attorney to represent you. You have a status conference on May 18th at 8:30 a.m. and a preliminary hearing on May 20th at 8:30 a.m. You are eligible for release. And the court is imposing the following terms. You have a secured appearance bond in the amount of $1,500. You have additional terms of release, including can't go back to the scene of the alleged crime, all right? No contact with any alleged victims, no drugs, no alcohol, all right? Do you have any questions?
Yes, you told me at the end you asked me if I have any questions. Ma'am, my face and my neck is swollen because the guy that allegedly hit me, I was getting ready to pay for my items, and he just came out of nowhere and just started striking me all over my body. And as far as burglary, I would never burglarize anything. And I don't know where burglary came from, ma'am. I'm just totally confused where burglary came from. That right there is a charge that I should not be getting charged for at all, and not even for assault. I was trying to protect myself. My face is swollen, my lip is swollen, my neck is swollen. I have bruises all over my body. I'm trying to explain now.
Let me answer the questions for you, okay? So the police submitted on 1 count of burglary of a non-residential structure, all right? And that is, basically defined by the law as entering or remaining unlawfully in a non-residential structure, so which would include a store, with the intent to commit a theft or a felony therein. Now, I'm not saying that that's just the allegation, but I want to explain to you what burglary in this situation is under the law, okay, what the definition is. So the court did find that, there is probable cause. Now, you're a long way away from being convicted of that, all right? This is just a probable cause determination. And I will tell you, ma'am, that the state, so the county attorney's office, they did submit a recommendation to this court on what your release condition should be. And their recommendation was $12,500, okay, of a secured appearance bond. So this court has taken all of the information that it has before it, and it did not impose a $12,500 bond. The court is imposing a $1,500 bond, all right? So I hear what you're saying to me. Again, you have an attorney that is appointed to help you and represent you in this matter. Your next hearing is in just a week. And you can certainly discuss all of these issues with your attorney.
I definitely will, ma'am, because I don't appreciate me having assault or burglary on my record, ma'am. This man, I'm a woman and he was a man. He beat the living daylight shits out my ass. And and he didn't even get arrested, but I did. So it's fucked up. It's totally fucked up, but yeah.
All right, that concludes your hearing, okay? All right, the court hears you, okay? So that does conclude your hearing, all right?
Okay.
Get your paperwork, it's right to that way. Thank you so much. All right. Christopher Armendariz and then Angela Hicks. All right, may I have your name and date of birth?
Christopher Lee Armendariz, Paul 2986.
All right, thank you so much. All right, you are here. All right, you're here on one matter. That matter is allegations of new offenses. One count of threatening and intimidating, that's a Class 1 misdemeanor. One count of criminal damage, a Class 1 misdemeanor. And one count of disorderly conduct is a Class 1 misdemeanor. All right, the court has found probable cause as to all three of these allegations. And the court is appointing an attorney for you. That attorney will be assigned and appointed officially appointed at your next hearing, okay? Which is on May 18th at 10 a.m. You are eligible for release. You have several very important terms of your release. I'm going to go over them with you, okay? You have a secured appearance bond in the amount of $1,000. Additionally, you're ordered not to return to the scene of the alleged crime.
I live there, though. How can I not return there?
I understand. So, I gathered from the probable cause statement that it is your place of residence.
Yeah.
Even if it is your place of residence, you cannot go back there except the court is authorizing a one-time civil standby that is to be conducted by the police, by law enforcement, to pick up your belongings, okay? Do you understand that term?
Yes, I do.
Okay, it's very important that you not go back there except for the civil standby.
Okay.
Additionally, you're not to have any contact with any of the alleged victims. Do you understand that?
That's my family, though. It's kind of impossible.
Okay, well, at least until this order is lifted, in the future by the court, you're not to have any contact with them.
Yeah.
Okay, regardless of who they are to you. Do you understand that?
Yeah.
Okay. Failure to abide by these orders, so the orders for no victim contact and not going back to that house, could result in new charges being filed against you. Do you understand that?
Yeah.
All right. Further, the court is ordering that you not possess any weapons. Do you understand that?
Yeah.
All right. Additionally, no drugs and no driving without a valid license. Okay? And finally, you must find an alternative residence, and you've got to provide proof of that residence and that address to the court by your next hearing. All right?
All right.
Okay. That concludes your hearing. Thank you.
Thank you.
Angelina Hicks, and then we will have Matthew Dancer. May I have your name and date of birth?
Angelina Hicks, April 23rd, 1987.
Okay. All right, you're here on one matter, and that is give me 1 second. All right, so that's a warrant for failure to pay child support, and that is out of Mojave County, okay? The court is appointing an attorney to represent you, and that attorney will be appointed at your next hearing, which is on May 14th at 8:30 a.m.
Okay.
Right? So you have a $400 cash purge amount, okay? So you'd have to pay that amount before being released.
Okay.
All right? Do you have any questions?
No.
Okay. All right. That concludes your hearing. Thank you.
Thank you.
Matthew Dancer, and then Hassan. Hello, may I have your name and date of birth?
Matthew Jason Russell Dancer, February 1st, 1971.
Thank you. All right, so you're here on one matter. That matter is allegations of new offenses, one count of possession of dangerous drugs, a class 4 felony, and one count of paraphernalia, a class 6 felony. The court has found probable cause as to both of those allegations and is appointing you an attorney. You have a status conference on May 26th at 8:30 a.m. and a preliminary hearing on May 29th at 8:30 a.m. The dates, times, and locations of the court hearings are on your paperwork. You're eligible for release. The court is releasing you. The court is not requiring a bond, but the court is releasing you to pre-trial services. So you'll get some paperwork on how to contact them. You have to make sure that you abide by their rules, basically, okay? You have additional terms of your release that are going to be written in your paperwork, and among those are no weapons, no drugs, all right? But make sure that you read the full list. Okay. All right, that concludes your hearing. Thank you. All right, Hassan, please. All right, may I have your name and date of birth?
Hassan, 10/17/07.
Okay. All right, you're here on one matter, okay? You're here on an allegation of a new offense, disorderly conduct, a class 6 felony, okay? So the police are alleging that, you committed disorderly conduct with a weapon, which makes it a felony. So the court reviewed the information available from police so far, and the court is finding that as of today, there's not probable cause to support this allegation, okay? So you've got to understand that I have just a very, very limited amount of information for these hearings that comes from police, all right? And so even though the court is not finding probable cause today for this allegation, doesn't mean that you won't ultimately be charged for this, okay? So new information and more information may come in, and you may be charged by the county attorney's office, even though this court today is saying, I don't find probable cause. Does that make sense? Mm-hmm. Okay. So, even though I don't find that there's probable cause today, the court is still appointing you an attorney to represent you, and you still have hearings that you have to attend. So you have a status conference on May 26th at 8:30 a.m., and you have a preliminary hearing on May 29th, also at 8:30 a.m., okay? Mm-hmm. So you've got to make sure that you attend those hearings. Yes, and you'll have an attorney that will meet with you, all right, at those hearings. Now, because I'm not finding probable cause today, you don't have any release conditions, okay? So that means that you don't have to post a bond, you don't have any terms of release. So you're being released, right? Mm-hmm. But you've got to be at those next court dates. Do you understand that?
Yes, ma'am.
Okay. All right. That concludes your hearing. Thank you.
So I'm going home? Oh, thank you. Mm-hmm.
All right, and then can we have everyone cleared for our last one? Okay. So our last one in the courtroom will be Gerald Moon.
I'm waiting on the meeting.
And they're trying to get him out.
Come this way. Sir, the podium right here. Who? Go to the podium. Okay, okay. Move your hat. In the courtroom. Yes, sir, yes, sir. Hello.
Hello, sir. Can I have your name and date of birth, please?
Ma'am,
Can I have your name and date of birth?
my name is... I'm trying to remember. My name is Gerald Moon, and my date of birth is... I forgot.
Let me see if this sounds familiar. Is it November 27th, 1960? Okay. You know what? That's okay. That's all right. All right, so you're here for your initial appearance, and you're here on a matter involving allegations of new offenses, specifically one count of indecent exposure, the Class 1 misdemeanor, one count of indecent exposure as a Class 6 felony, all right? 2 counts of disorderly conduct, both of those are Class 1 misdemeanors. 1 count of criminal trespass is a Class 3 misdemeanor. 1 count of luring a minor for sexual exploitation is a Class 3 felony, and 1 count of sexual indecency with a minor present is a Class 5 felony. All right, so the court has found probable cause as to all 7 of those offenses, and the court's appointing you an attorney. You have a status conference on May 18th at 8:30 a.m. and a preliminary hearing on May 20th, also at 8:30 a.m. The court notes that it is in receipt of 2 victim impact statements as well as a recommendation from the state. The state's recommendation did recommend a secured appearance bond. And their recommendation was a secured appearance bond, a cash-only bond in the amount of $200,000, all right? So, you are eligible for release.
Thank you.
Okay, and just give me one more second. The court is imposing the following terms. The court's imposing a secured appearance bond in the amount of $25,000, all right? If you post that bond and are released, you'll be released to pretrial services. Before you leave the jail, they'll put an ankle monitor on you. You'll have to abide by a curfew, the time of which will be set by the pretrial services officers, okay? You have other terms of release. You're not to go back to the scene of the alleged crime, no contact with any alleged witnesses or victims, no contact with any minors, no weapons, no drugs, no alcohol, and you are ordered not to leave the state, all right? Okay, thank you. That concludes your hearing. Everything's written down in your paperwork, all right?
Thank you.
All right, and then Deputy, my understanding is that Chamberlain, Johnson, and Silva could not be transported, either because they were a disruption or some type of safety or health consideration. Okay, fantastic. So we will do all three of those in-house. And for the record, I will quickly go through them. So Joseph Chamberlain is here on a probation violation matter, alleged to have violated terms 3 and 5 of probation. The court's appointing an attorney. There is a probation revocation and possible disposition on May 18th at 8:30 a.m. Mr. Chamberlain is eligible for release. There's a secured appearance bond in the amount of $100. The remainder of the release conditions are written down. Michael Johnson is here on a post-adjudication arrest warrant on a domestic violence disorderly conduct case out of Peoria City Court. An attorney will be appointed at the next hearing. There is an arraignment hearing on May 14th at 9 a.m. Mr. Johnson's eligible for release. There's a secured appearance bond in the amount of $500. All additional release conditions are in the written paperwork. And finally, we have Svetlana Silva. Ms. Silva is here on a matter involving allegations of new offenses, specifically assault and disorderly conduct, both as Class 1 misdemeanors. The court has found probable cause as to both of those allegations. An attorney will be appointed at the next hearing. The next hearing is an arraignment hearing on May 26th at 2 p.m. Ms. Silva is eligible for release. The court is releasing her on her own recognizance with the remainder of the release conditions in the written orders. Finally, the court notes that if anything changes after meeting with these three individuals, the written orders reflect the court's final orders. With that, we will go off the record and then